Good morning, everybody. It is August 12th. It is 9:33. This is the Colorado Oil and Gas Conservation Commission's hearing. We will continue with our docket on the KPK matter, which is docket 2011-00261. We should bring to the panel attorneys for staff and attorneys for KPK. And then we would start with the soil spread field matter. Before we do that, let's take the roll. Hearings Manager Larson.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez.
Here.
Commissioner Hackett, Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Which is the 5 that we anticipated having. So welcome back, everybody. Good to have you. Good morning, Ms. Stafford. Good morning, Mr. Jacobs. I believe we will roll into NOAV 4024-94406 soil spread field. And I believe we will start with staff. Before we do that, do either of you have any procedural matters for us this morning?
Chair Robbins, I guess I would just like to get some clarification on when we'll be discussing the rest of the schedule in this matter, or in these matters, I should say.
Yeah, I think where I bumbled along to at the end of yesterday's meeting was we would do that either later at the end of the day today or first thing in the morning. I wanted to give everybody 24 hours to talk with clients and witnesses and all that. Frankly, it's really up to you and Mr. Jacobs. Whenever you're ready, we can do that because I don't think it's necessarily, I don't need to go talk to myself about my availability. So maybe you guys can tell us when you want to touch base on process for later things.
Sure. Staff reached out to KPK last night to at least let them know what our availability is. But I know that Mr. Jacobs was checking with his client about availability. So I can turn it over to him if he would like to discuss that more. Mr.
Jacobs.
I have some dates end of next week and early the following week from Ms. Stafford. And we have a conflict on the first of those dates. We're confirming the availability on the remainder of those dates with witnesses and clients. We'd be prepared to speak perhaps after the lunch break and lock that in or end of day, but I think we'll be able to reach agreement on a couple of dates to do the remaining 3 NOAVs and closing argument on those. If we can get that done in 2 days, or we may need to look at a third date, but we'll be responding by email, and maybe you and I can confer over the lunch break, and then we can do this for the benefit of the chairman and the commissioners and the hearings manager at the end of the day. So we are working on that. Thank you.
Thank you both for your cooperation and collaboration on that. Let's touch base at the beginning, right after lunch, and if we're still sort of making inquiries, we can touch base at the end of the day.
Very good. Thank you, Mr. Chairman.
Anything else, Mr. Jacobs, procedural wise?
Not at this time. Mr. Mueller is going to lead us on soil spread field, so I'll turn it over to him.
Very good. Ms. Stafford, are you or is Ms. Rosenberg leading on soil spread field?
Ms. Rosenberg will be leading on soil spread field. Thank you.
Okay. Ms. Larson, can we get a time check for the parties before they get started this morning?
Yes, we can. So KPK has 3 hours, 26 minutes, and 36 seconds remaining. Staff has 4 hours, 7 minutes, and 52 seconds remaining.
Okay. Ms. Rosenberg, you are recognized. We look forward to hearing from you and your presentation.
Thank you. I am trying to find which screen to share here, and for some reason I'm having some difficulty. Give me just a moment. Good morning. Sorry about that. Everyone can see my screen now? Is it the soil spread field?
Yes, we can see it.
Sorry about that. I had practiced earlier and I don't know what happened there. Good morning, commissioners. Now you will hear about the soil spread field situation. As you know, in this matter, KPK took hydrocarbon contaminated soil from its Nesu #1 excavation and dumped 300 dump trucks of this oily dirt in the field behind its office. As a basic overview, the parties had stipulated to many of the facts here, including KPK admits that it took excavated soil from the Nesu #1 and spread it across the field behind its offices. The field behind KPK's office was not and is not an accredited landfill or a centralized E&P waste management facility. When deciding which soil to take to the field behind its office, KPK admits that it did not test the soil for compliance with Table 910 standards. The spread field is within yards of a freshwater pond in mapped wetlands and is about 2 acres in size. Moreover, the parties agree that staff observed hydrocarbon staining on the dumped soil during its June 30th, 2020 inspection. KPK denies that its admitted actions violate any rules and have suggested that their alleged lack of intent somehow relieves them of their regulatory obligations. However, the evidence will establish that it is more likely than not that KPK violated Rule 324 Big A because the contamination to soil near wetlands in a freshwater pond resulted in significant adverse environmental impacts. In addition, staff alleges 3 distinct violations for KPK's failure to properly manage and dispose of its E&P waste and for disposing of it at an unlawful location. The evidence will also establish that these violations resulted in major adverse environmental impacts, some of which were ongoing for months. And at this point, staff would like to call Dr. Peter Gintadas. And I'm sorry, the way that my screens are set up, is Dr. Gintadas available? Is he present?
We are bringing him in. Let's
Thank
give him just a second.
While we're waiting, may I ask counsel if she has an exhibit number or identification for this photo?
This is from Exhibit 5. This is just a demonstrative.
Good morning, commissioners.
Excuse me, for the record, we have objected to Exhibit 5, and we wish to renew that objection. Certainly, use as a demonstrative, I think, is permissible here, but we've not admitted Exhibit 5 into evidence.
Ms. Rosenberg, you're not trying to admit Exhibit 5. It's a demonstrative only, right?
Correct.
Okay, good.
Thank you.
Just bear with everybody. Hearings Manager Thomas, are we able to get this screen looking something other than green at this point? I really do like having 2 screens. Okay. Okay. Ms. Rosenberg, you are free to start with Dr. Gintadas.
Thank you. Good morning, Dr. Gintadas. The
morning.
commission already knows, oh, pardon me, sorry. The commission already knows who you are, but did you do anything to prepare for this matter that was anything different than you did to prepare for the Nesu matters?
No.
All right, thank you. I'd like to ask you some general questions about the soil spread field. Could you describe for me the basic history of your involvement with the soil spread field?
Yes, I was contacted through our, I think my supervisor at the time that an anonymous complaint had come in that appeared to be in the area I cover. And as part of that, we requested to visit the site in question with the operator under various parts of the statutes. There's not a defined oil and gas location there from the past. We created what's called a location and a non-facility so we could put in inspections with respect to this.
And when did you first inspect the soil spread field?
The first time was on June 30th, and I visited it with Kari Brown from our staff, and Max Knopp was there from KPK.
And what did you observe on June 30th?
I'm sorry, but times are important and dates. June 30th of what year?
2020.
Thank you.
And what did you observe on that June 30th, 2020 inspection?
There was a fairly large area of soils that had been moved around. There was I believe a front end loader or a bulldozer there, both perhaps. And it appeared that soil had been spread around the field, which was alleged in the complaint that there had been, I believe the complaint only thought there were about 75 or 100 dump truck loads delivered there. I think by the count from later on provided by the operator, there are 300. And there's an area, we took samples as well over there. There's certainly differences between the...
Yes, we'll get to that in a moment,
Okay.
Dr. Gaddis. Can you tell me a little bit about what's going on in these red marks here on this map?
Sure. To the bottom of the map, there shows a small irrigation pond, and it's also a mapped wetland. And then that's marked on there both, and that's maintained really by putting irrigation water in there at the moment. That's why there's a pond there. It probably was a natural wetland before that. There's an area shaded, which is indicated as earth material spread field. And this air photo is from before the materials were there. That's simply a polygon from my mapping activities in the inspections to account for where we saw kind of a clay and rich or clay rich sand material with no vegetation growing on it.
Thank you. And then here's some more photos from your inspection, identified as Exhibit 816. Can you tell me a little bit about what these are showing?
Yeah, this is from July 21st, 2020, as it's labeled on the photo. And this again was an inspection with a KPK employee there. And I have to admit, I don't have in my notes who it was, but I had alerted them that I was going to go out and take some further observations at that day, and they wished to come out as well. And you can see there's material spread there. It's been spread by bulldozer and on both slides. And to the very north at the left-hand one where those trees are is a mapped wetland on the west-hand side. And we showed that on the other aerial. I didn't specifically discuss that, but there are mapped wetlands in here, sensitive areas that in the way our rules deal with things.
And when you were first inspecting the location, what were your general environmental concerns?
Well, when we started sampling, we looked at it a little bit and started sampling, and it certainly was a different material than the native soils there. The native soil is a loamy sand. It's kind of a coarse sand. It's known as the Vona loamy sand in the soil service mapping efforts of the area, and that pretty much the whole area of the spread field is that soil map type. And then we started taking, we used a tape and started taking samples, composite samples down that line. That line represents the center. They're about 50 feet apart.
Dr. Gaddis, what do these green, what's the difference between the green and the red?
The green ones are baseline samples where there had been just native soils. From what I could tell, there were grasslands that had not been disturbed. And that's partly to get some idea what the native soils are like, because some of our criteria from Table 910 and now from Table 915 take into account background concentrations.
And when you were present on June 30th, 2020, what observations did you make to suggest that there was hydrocarbon stain, impacted soils placed there?
Well, there certainly were some visual and olfactory things noted by us and by Max Knopp, who told us there were a couple spots that he noted, visual and olfactory indications there were stained soils, and in a few places here and there, not everywhere, not highly stained anyway in all areas. But we took samples to send to a lab to get better definition on what was there.
Thank you. And then how did you calculate how much oily waste was dumped at the spread field?
Well, they provided us with trucking records from waste that was hauled from the NESU one over there. They're not manifests in the normal sense. It's simply internal work tickets. And I documented in a spreadsheet, which I think you've printed up there, the dates and, well, that's actually you've put up the two different spreadsheets there. The one on the left is the one for hauling into the site. And I just added up the dump trucks, and there were 300 loads, and I made some estimates of volume and came up with about 3,570 yards of material brought in, and that's in the ballpark of what they had estimated in their reports to us, and I don't have the exact number that they estimated. The one on the right-hand side is from manifests for hauling the waste away to the landfill. They hauled away from the manifests and from the landfill tickets. I came to a total of about 4,500 tons hauled off to the landfill.
And just to clarify, that's what was hauled off from the spread field eventually to the landfill.
Right.
And then can you describe for me in terms what the significance is of 3,570 total yards? What is that? What does that entail? Is that significant?
That was depth of, say, at least a foot over the 2 acres to maybe 2 feet in some parts, and maybe a little bit more in places because it was an uneven. It was a work surface that had tracks and things in it, so it's not a perfectly level. And nobody had tried to level it. Obviously, it just had been brought in there and spread out. So it's about 2 acres in size, and my estimate was it was in the order of a foot to 2 feet deep.
And is it safe to say that's a lot of soil?
It is.
Is this a typical situation in your experience for operators to take soil from an excavation and take it to a different location?
No, it is not.
And so now we've talked a little bit about the actions leading up to the general overview of the soil spread field. But now I'd like to talk about KPK's actions leading up to dumping this oily waste in the field. As the commissioners know, and everyone knows from yesterday, KPK segregated the soil at the NESU location by visually observing the soils at the excavation using olfactory observation and photoionization detection. Understanding that the commission had a lot of testimony about this yesterday, can you tell me what is wrong with that approach in this situation?
Certainly, the photoionization detector can, as John Peterson and John Exon both explained yesterday, responds largely to volatile organic compounds. What was seen in the analytical data was long chain hydrocarbons from a heavier oil, and they would not volatilize in a normal situation unless you heated them up very strongly. And so they're really, even if there was no PID response, it doesn't mean there were not oily hydrocarbons in the soil. Also, there were impacts to the soil from the electrical conductivity from produced water impacts at the site. Those are not even remotely seen on a PID. The only way you can define those really is in a lab test, and that wasn't done. Those are markers of produced water impacts.
Thank you. And tell me then, tell me about KPK's activities with that EMP waste relative to how they work to prevent threatened or actual significant adverse environmental impacts.
Well, I didn't, neither time I was there in 2020 in June or at the end of June or in the 21st of July, there were no stormwater BMPs. There's no kind of containment there. It simply had been spread out. There was no way of minimizing migration if there had been a large rainstorm or whatever. It did happen to be dry, I believe, in that time frame, but that doesn't mean if you have waste out there, you need some kind of containment around it, as we've discussed in some of the other matters.
Thank you. What could KPK have done to ensure that this oily waste was appropriately stored?
Well, in terms of our rules, they would have had to.
Excuse me, I'm going to object to the repeated use of the phrase oily waste. There's no testimony to suggest that what we're looking at here is oily waste.
It is hydrocarbon stained soil.
That's fine. It's
Okay.
not oily waste.
I will refer to it. What could KPK have done to ensure that this EMP waste was appropriately stored here?
As I said, they would have had to have permitted a centralized EMP waste management facility or a land disposal site with us. They did neither of those things.
And then similarly, can you tell me about KPK's activities relative to how they handled this EMP waste to ensure compliance with Table 910 standards?
Well, simply spreading it out is, in an unused area is not in compliance with our rules. And so it just should never have been hauled there.
And let me ask this another way. Did the lack of testing impact?
Yes, it did.
Can you expand on that a little bit?
The fact they didn't test it meant that things that did turn out to be in exceedance of Table 910-1 for several compounds were brought to a site where it was not permitted.
And then similarly, through the mechanisms that KPK employed, how could that have ensured compliance with Water Quality Control Commission groundwater standards and classifications?
Well, there is shallow groundwater there. It has been tested at this point, and there were not impacts, but it certainly, the process did nothing to minimize the potential impacts to groundwater or surface water, which is present within about 100 feet or so in the irrigation pond.
Thank you. Now I'd like to take a look at Exhibit 113, which is the NESU number 1, January 2020, initial form 27. Now, without considering whether an operator can generally dump clean soil from one excavation to an unlicensed facility, was KPK allowed to do this in this instance?
Certainly they did not tell us that or inform us of that, and I would have asked them to test the soil before they did that. Anything you're leaving at the site, we expect to be, the bottom of the pit or whatever, if you're testing to see that you don't need to keep excavating, we expect to see test results from that. We certainly didn't see that. We didn't see any screening data, any kind of visual or field observations. They simply told us that they had planned on, and even when they closed the NESU 1 remediation, that statement was still in there that all excavated soil will be disposed at Front Range landfill. That's what we expected had happened.
Right. And generally speaking now, would you advise an operator generally to dump excavated soil somewhere else without testing it?
No, not without testing.
Thank you.
At a lab.
Right, fair, yes. So you just discussed how you do not believe KPK appropriately handled and stored the EMP waste. Now I'd like to focus on the impacts caused by the dumping of this EMP waste.
Commissioners, I'm going to interrupt, and I apologize, Ms. Rosenberg. It's my understanding that the parties, in the course of reaching stipulations in this matter, landed on the phrase removed soil rather than EMP waste or oily waste. And it seems to me that's the appropriate language to use to refer to this soil.
We may have stipulated to that, but just a few moments ago, I clarified it as EMP waste and we decided that was appropriate. And I'm talking about the EMP waste here, not soil, talking about the waste itself and the environmental impacts it caused.
Mr. Mueller, thank you. I think the commissioners understand your point and we will take that into account. Let's just use the word EMP waste for now, and you will have every opportunity to reclassify whatever it may or may not be during your case in chief.
I appreciate that, and I'm sorry, Ms. Rosenberg, for the interruption.
Oh yeah, no problem. So then what happened next? Tell me a little bit more about what happened on your July 21st inspection.
Well, that was partly just to see the site again and to kind of map it better than I had the first time, make sure I had the kind of the outline correct and take another look at it. It was not, by that time, I believe I had received the lab reports, and that's why I wanted to go back and make sure I had a good mapping of the area, not just the points that I had taken samples at. So that was my main reason, was to document with more photos and get coordinates so I could plot up the outline of the spread field.
And then can you tell me a little bit more about the results, the analytical test results that you obtained?
Okay. There were many things tested, including extractable petroleum hydrocarbons, the range of metals that were in the table 910-1, and also a couple of what's now in the soil suitability parameters, electrical conductivity in terms of millimos per centimeter, and sodium absorption ratios.
And here I have
which we talked about yesterday a little bit.
Pardon me, Dr. Gintatis, I truly didn't mean to interrupt you there. It was just a function of the weird Zoom.
I understand.
Let me take a step back, take a look at what I have posted here. And I have some images from your July 21st, 2020 inspection report.
Right.
Can you walk us through what these figures are describing?
Sure. They show the sample locations again, and then with each sample point is labeled as to the concentration.
And then what was
from the lab?
What was tested in each of these photos?
Well, TPH is total extractable petroleum hydrocarbons, so essentially the oil part of TPH.
And what does the red and the blue, what do those indicate?
Again, the red is inside the spread field. The blue is the background samples.
And what did your results find here?
In each of the samples from the spread field, there were crude oil present. Not all of the samples were over the 500. There were, I believe, at least 3 or perhaps 4 that were over the 500. By definition in the rules, if TPH is over 500 milligrams per kilogram, it's an oily waste. In terms of the EC, each sample was over the table 910-1 limit in the spread field, and the background samples were a factor of something like 10 to 15 times lower than in the spread field. The sodium absorption ratio was within the table 910 limits, but it still was quite highly elevated by a factor of 5 or more, I think, in general, higher than the background samples. And the arsenic concentrations were all over the threshold at the time in table 910-1, and as were the background samples, but the spread field samples were an order 2 or 3 times the background samples.
And what is EC?
It's electrical conductivity. It's a parameter that, because produced water tends to be high in salts, when it interacts with soils or sediments, as it did at the very weathered part of the Nesu 1 site, it leaves behind parts of the salts tied up with the clays, and it can impact soil growth, or not soil growth, but plant growth on soils.
And then can you just explain, what does AS stand for?
It's arsenic.
Thank you. And can you explain to me the significance of these test findings?
Well, in terms of the EC, every sample was higher than the limit, which has a strong tie to impacts from produced water in soils. So we know that the pipeline carried both produced water at the Nesu 1 and oil. And all of the samples in the spread field had crude oil in them. They were not all over the 500 that would make it oily waste by definition, but there certainly was material in there that was oily waste from the testing that was done.
And in your view, based on your experience, is this a significant adverse environmental impact?
Yes, if it was still at the spill site, as it had been, it would have had to be removed for those reasons, because it wouldn't have met the Table 910-1 standards and could not be left there.
Thank you. And kind of along those lines, in its answer, KPK said that they didn't dump the impacted soil or EMP waste at the spread field, and that the high concentrations that you discovered here are simply a result of poor native soil quality at the Nesu location. But if I understood you correctly now, you disagree with that.
Yes, I certainly do. The analytical data that I reviewed is very clear that there are crude oils in the soil. It is not just naturally occurring organic material. The background samples have some naturally occurring organic material, and it's a much different pattern. I spent 15 years managing and running labs doing organic analysis, and I'm an expert in identification of patterns and what's in there, and from petroleum hydrocarbons or products, and that is my professional opinion.
Thank you. I'd like to move on a little bit and ask you a couple of questions about why, pursuant to commission rules, the spread field was an inappropriate place to dump this EMP waste. Generally speaking, can you just clarify for me, without specifics, what is the cost of dumping a load of soil at the spread field versus going to a landfill or a certified facility?
Well, you'd have to ask Kaufman exactly what that was, but I believe they're probably in the range of $50 to $70 a ton.
To go to which, I'm sorry, which is 50?
Plus that's the waste disposal fee, and then the trucking there. I cannot really estimate. They use their own trucks to some extent on some of this. I think they also hired out trucks, and there's probably some different prices involved in that in the long run.
And how do you generally know about the price distinctions here? Just through your experience?
The prices for landfills, I believe that, I've asked other people what they paid in the past for disposing of oily waste at the landfill. And it depends what landfill and what kind of contracts they have. I don't know exactly.
Sure.
It'd be a question they would have to answer.
And the parties have stipulated to this, but to your knowledge, did KPK ever seek or obtain or talk about obtaining a permit for the soil spread field to be utilized as a centralized EMP waste management facility?
No.
Thank you. Now I'd like to just talk a little bit more about the ongoing nature of these impacts. Tell me a little bit about KPK's actions following staff's discovery of this EMP waste. What did KPK do with this soil, and how are the impacts addressed?
They reported a spill at our, again, we asked them to report it as a spill based on the analytical data after I transferred that to them in the July 21st, I guess it was, 2020 inspection. They did send in a spill report with some further details and told us that the material had come from around that time they had done a field inspection resolution form and stated that the material came from the Nesu 1 site and gave some approximate volumes of material transferred there. We also, as part of the spill, asked them to do a Form 27 to document how this material would be removed, which they did. And then later on, I don't know the exact dates. I wasn't out there that much, but I know they started scraping this up and putting it into a big pile for then loading into trucks and hauling it off. And I don't right in front of me have the last date it was hauled off. I think it was in March of 2021. So the impacts remained there with no controls on them, as far as I know, from May, or even I think it started in April of 2020 to about April of this year.
And sort of along those same lines, can you tell me why staff used the environmental violations, the 324 Big A and the 907, as accruing until June 20th, 2021?
Yes, that's when they submitted data showing that in large part the material now met the table 915 standards. What was left there, there are still some SAR exceedances which could be dealt with in a reclamation route through Rule 915B, and they agreed to go out and do some further background sampling for arsenic to show that what was left was in the same range, and we haven't, that data is still pending, but I expect that they will be able to show that the arsenic is within the background of the native soil at the site, which is what's required under rule in the 915 rules now.
And I'd like to tease out just a little more. Why did you not consider the corrective actions to be sufficient simply when the soil, the EMP waste was hauled off?
Well, it had not been documented. I mean, it is true it was hauled off. The matter of documenting it to complete the processes, to me, is part of that process as well.
And so
it takes a while to do that. I'm not, it's a matter of I guess, of some concern here, because if they hauled it off and it still didn't meet the the table 915 thresholds, then it would still be contaminated. So I view it as when they documented substantially that they're in compliance.
Thank you for that. And am I understanding you correctly then that there wasn't, KPK did not provide a lot of documentation about their activities here relative to impacts?
They did updates to Form 27s and put in dates and when they were doing things. And I did not really need, in this particular case, I could see from out on the county road that they had started the process because I could see the pile of dirt. I did not go in and do a separate inspection of that once they had started the process. And I saw dump trucks there. It's a major county road. It's near, I go down, up and down it in my business work to go to field sites and things on a fairly consistent basis. And I could see they were in the process of doing it, even though I was not right there at the site.
Thank you. At this time, I have no further questions for Dr. Gontadas. Thank you.
Chairman Robbins, with your permission, I have a few questions.
Yeah, I was trying to find my unmute button there, Mr. Mueller. You are recognized for cross-examination.
Thank you. Mr. Gontadas, did you say you observed stained soil at this location?
Yes.
Did you take any photographs of those stains?
I took samples and sent them to the lab.
Was that part of the grid of sampling that
yes.
you illustrated? Okay.
Yes.
So the answer to my question is there are no photos of the stains.
There are photos of the soil. I can't tell you right
Objection,
now.
the party stipulated to this as a fact.
Yeah.
Well, we stipulated that staff observed stains. My question is whether there were photographs of the stains.
I can't tell you right off the fact. I took samples of each sample site. I'm not clear whether it showed up in them or not. Obviously, visual and olfactory things, sometimes you're holding it up and, we're sampling. Some of that you smell or see while you're in the process of sampling. I maybe did not take a picture of individual things. I purposely tried to take what I saw was representative samples. That's why we did composites over a course of 50 feet. And they simply, some parts of them had that. I can tell you that Max Knopp told us the same thing at some different sites in there, that he noted visual and olfactory things while we were there.
Thank you, thank you, Doctor. Did you take any background samples at NESU 1 to compare with the quality of the soil at
No, it doesn't have any bearing in this. Our rules are very clear that local background is what has to be used.
Thank you, Doctor. I don't mean to talk over you. On the other hand, we have limited time, and I apologize for interrupting. The answer is no, you didn't take any samples at NESU 1 to compare for background purposes.
Yes, because it's not appropriate to do so.
I'm going to share my screen. Dr. Gonzalez, can you see my screen?
Yes.
This is the notice of violation that we've been discussing, correct?
Yes.
There are 4 alleged violations here. The first one is for Rule 324A sub A. Described here that staff noted hydrocarbons emitted from spread soils at the location, and then in the next paragraph that the operator had indicated the soil was moved here from another location from the NESU one. You see that in the highlighted language?
Yes.
There's another violation then, 907.A. Here too, it's based on the fact that there was soil spread across some 9,000 feet, and noted too that this soil came from the NESU one. You see that?
Yes.
Here is another violation, 907.E.1. Same allegations here, documented that soil had been spread and that it came from NESU. You see that?
Yes.
And then finally, for the 4th offense violation, same thing, the soil spread that came from NESU, correct?
Yes.
So the same activity, the same behavior has given rise to 4 different violations, all of which have been cited against the operator and fined against the operator, correct?
Yes, I believe so.
For the same activity.
The same general activity that resulted in many violations of rules.
Okay. One of the violations, I guess it's the last one, failure to get a permit for a E&P waste management, centralized E&P waste management facility. Do you agree with me?
That is what that rule is about, yes.
Did you understand that KPK intended to construct a centralized waste management facility when it removed this soil from NESU to this location?
I don't know what they intended.
If they didn't intend to make it a waste management facility, would you have anticipated that they should have applied for a permit to do this?
If they're aware of the rules state that there's certain ways of disposing of oily waste, and this centralized E&P waste management facility permit is one of those ways. They did not choose to dispose of the oily waste in any of the approved methods.
Well, you understand from testimony that happened previously that they did not realize, they were thoroughly unaware that this was, as you call it, oily waste.
It is still their responsibility to know that. That's part of doing a cleanup at a site, is knowing characterizing the waste properly and deciding how to deal with it once it's characterized.
Thank you, Doctor. If one of the trucks going from NESU or going from soil spread field to the disposal facility turned over on the road and spilled soil onto the road, would that truck driver get fined for operating a waste management facility without getting a proper approval?
He is not an operator. The operator is responsible for that waste.
Well, you would agree with me, would you not, that there is some component of the 908 regulation that presupposes intent, that anticipates that the person who seeks to get the site authorized is intending to construct a waste management facility and not doing something accidentally?
Objection calls for a legal conclusion. He's not a lawyer.
Accepted, and you're quite right. In your lay opinion, but as somebody who is a regulator and inspector and the person who writes up violations, isn't this really intended for people who, not for accidental situations, but for deliberate situations?
Yes, because people know they've characterized their waste and they know that they want to deal with it per the rules, not just say, well, we don't really know, because by choice, we chose not to characterize the waste appropriately.
So they admittedly made a mistake and admittedly transported soils but they didn't intend to operate a waste management facility. You would agree with that?
That I don't know that.
Okay. The same line of questioning is true, is it not, for the violation above that, 907 sub E? Would you agree?
I'm not sure what you're asking me to agree with, that there is a violation of 907.
Mr. Mueller, I disagree with this line of inquiry for this witness. You're asking him to provide perspective on what the intent of KPK was. Why don't you reserve that for your direct case?
You're right, and I understand that he doesn't and can't speak with knowledge about their intent. Really, my question focuses more on the spirit of these two rules, and I would suggest and ask him one more time if he would agree that these contemplate deliberate actions and not accidental actions.
I think they contemplate both. It's telling you how to deal with waste that's been properly characterized.
Thank you, Doctor.
It was their choice to not characterize it.
Thank you, Doctor. Do you know the condition of the wetland today that you identified in the prior testimony?
I was there in the last month or two. I don't have the exact date in front of me. I went out there and met Jeff Rickard, and I observed some sampling he did of background sampling. And I did walk around there and take another background sample near the mapped wetland. It was not standing water. It is still a much different plant community and things. And I believe the mapping is from the Fish and Wildlife Service is appropriate from what I saw.
Right now it's dry, is it not?
It is.
The aerial photo that you showed earlier, over which you would graph the facility and put in the transects for where you took the samples. Do you know the date of that photograph?
Yes, it was in September of 2019.
So not at the same time that you were out there sampling?
No, at the time I could not obtain a Google Earth image for the current things. I could do that now, but we didn't go back and try to remake those slides.
That's fine. And, Google Maps only gets updated when it does. I just want to be clear that the photo that showed sort of a large green pond and wetland was not contemporaneous with the conditions on the site when you sampled. And
yes, it was. There was water in that pond when I sampled the pond in June of 2020.
But the photo was taken a year earlier. It's not the case that it would necessarily look the same if it were taken.
No.
Okay.
It's filled up when there is irrigation water running in the ditch. It may dry up in between times. That's what we've observed. And it was full again in the last month or two.
Doctor, the fine as it was measured runs from the completion of the remediation in this instance, correct? Which was June of this year, I think.
The remediation is still open. I anticipate that it will become closed once we have a little further data from the operator and further discussion.
You recognize and testified that there was remediation activity taking place well before June. Indeed, you drove by in your vehicle and observed dirt being piled at the site. Do you remember when that was?
A number of times over the course of the spring of 2021.
I told you that the collection of the soil began as early as September of 2019. Would you disagree with that?
I don't have the manifests and all that in front of me. It certainly wasn't hauled off at that time.
And 2019?
That may have happened. I'm saying it was not hauled off. It was still there. It was just being piled up. That's not the same thing as removing the impacts from the area.
I misspoke, Ms. Rosenberg. It was 2020. You're right. Did you see in any of your visits examples of soil being eroded away from this field into the environment, someplace it didn't belong during any of your visits at the site?
The size was slightly different at times, but I think that was from working it with the backhoe or the front end loader and bulldozer. I do not, I did not see significant amount of erosion off the site. It's a pretty flat field. If you've, you can't see that from the aerial photos, but I think your client's staff could say that there's very little slope to that land.
And you're aware that sampling was taken around the perimeter, around the edge of the field, and it indicated that there had been no contamination at those locations along the edge. Are you aware of that?
Yes, I have data that was submitted as background samples, and that I believe is true.
Thank you, Doctor. I appreciate it, and I don't have any further questions right now for this witness.
Ms. Rosenberg, redirect.
Sure, just a few. Thank you, Dr. Gontadas. So to hit upon what Mr. Mueller was just asking you about a couple of moments ago, there were 4 separate rule violations alleged in this matter, correct?
Yes.
And those rules are each distinct and different, correct?
They are.
And then I want to just circle us back a little bit, talking about KPK's actions in this instance. Do you remember Exhibit 113 that we were looking at earlier? It was the Form 27 from the NESU 1.
Yes.
Do you remember what it required KPK to do with the soil from the excavation at the NESU 1?
Well, they had said they were going to remove it to all the excavated soil to a landfill.
Thank you.
Front range landfill, and they did not do that.
And then Mr. Mueller characterized KPK's actions as they made a mistake. Would a responsible operator make this type of mistake?
It's certainly not my opinion that they would.
And is this a common practice? Do operators typically make this type of mistake?
No, we have operators who do have centralized E&P waste management facilities or land farms, and they're very careful about what they bring there and how they deal with it. And we regulate that just as we would other parts of the oil and gas exploration and production process.
And then one last question. Mr. Mueller was asking you about potential adverse environmental impacts like erosion as an example. Do you need to just observe every possible adverse environmental impact to believe that there is a significant adverse environmental impact?
Now, simply by placing the material there, they were causing a significant adverse environmental impact, in my opinion.
Okay, thank you. No further questions.
Well, now,
Mr. Mueller, did you have something?
If Chairman Robbins will indulge me, I guess I do have one follow-up.
Okay, one follow-up.
Well, Mr. Gontadas, once the soil was removed, and anticipating that, and until we know otherwise, there's no evidence as we sit here today of adverse environmental impacts to the environment that's left behind when the soil was removed.
Removed and documented that that there are no impacts, yes.
Thank you, Doctor.
That has not been documented to this point.
Thank you. Thank you.
Okay, commissioners, does anyone have questions for Dr. Gontadas on this NOAV? Commissioner Nanjapa?
Thank you, Mr. Chair. Dr. Gontadas, we heard from one of KPK's expert witnesses yesterday about the slow migration of petroleum hydrocarbons through soils, especially that may have clay in them. Do you believe that for the time frame that this waste had been spread on the soil field, that there could be some below ground migration that may be still ongoing?
Well, he was talking about in place material, and this had all been broken up and spread out and kind of the structure of the materials, it had exposed a lot of surfaces. So the material under it, directly under it, was of much different type, less clay, very sandy, and it would be very easy for a rain event to migrate, carry things into the subsurface in that case. Partly because they simply, as part of the process of bringing it there, they had dug it up, disaggregated it, brought it over there and spread it out.
So Dr. Gontadas, much like tilling soil, it then made the soil more permeable?
That is a possibility, yes, and it's a real possibility.
Was there any liner that you were aware of below the soils that were spread?
I saw no liner there, and they've never told us that there was a liner there.
Thank you.
Other questions from commissioners? Okay, seeing none, Ms. Rosenberg, I believe you are ready to call upon your next witness.
Thank you. At this time, we'd like to call John Axelson.
We're bringing Mr. Axelson to the panel. Give us just a sec.
Good morning.
Good morning, Mr. Axelson. So similarly, as it was with Dr. Gontadas, the commission knows who you are and your background experience, but did you do anything different to prepare for today than you did in the other matters for which you have testified?
Not generally. I did check with one staff member to gather some specific information about this issue.
Oh, thank you. I would just like to ask you a few questions regarding the size and the impacts of the soil spread field. So at the outset, I'd like to ask you a little bit regarding the adverse environmental impacts. What is the significance of the 2-acre area of land being disturbed?
Yes, just from the start, to bring material to that location and spread it over 2 acres, they disturbed 2 acres of land. Even if there were no contamination issues, this site, you know, they had to over excavate a little bit of material to remove all of the impacted material. So they removed topsoil from this location, and it has to be reclaimed properly. So it has been disturbed just from that activity.
Thank you. And then talking about transporting the oily waste or the EMP waste rather from Nesu to the soil spread field, what is the difference in price? Are you aware of the difference between taking that sort of waste to a proper facility versus taking it to the spread field?
Yes, the current gate fee for disposal at the Front Range landfill is $72 per ton. So in this case, the 4,477 tons of material that was removed, that's documented, I believe it was Exhibit 826, would have cost $321,984. So there is probably some extra material they had to remove from the spread field location, as I indicated. However, KPK benefited financially over $300,000 by not properly disposing of this waste. And had we not received an anonymous complaint, we would have never known about this situation.
Thank you. I have no further questions for you at this time.
Mr. Mueller.
Thank you. Just a couple of questions for Mr. Axelson. Do you know who owns the land that we're talking about, Mr. Axelson?
I've been told that KPK owns the land.
And in as much as the KPK had to transfer that soil to the facility, they didn't gain anything, did they, by taking it to this facility, correct?
Well, had we not found out about it, they certainly would have. But yes, they did end up having to incur the disposal costs.
And you heard in testimony yesterday, the original intent was to return it to the excavation at Nesu 1.
I did hear that testimony.
No further questions, Mr. Chairman.
Redirect, Ms. Rosenberg.
No redirect, thank you.
Commissioners, questions? Commissioner Nanjapa?
Just a very quick one. I actually meant to ask this with Dr. Gintadas, but I think there was a question about, it was 3,500 some yards that were hauled, but then the landfill manifest, I think, was 4,500 tons. I was just trying to understand that difference. I don't really know the volume difference between the yard versus a ton. Is that something that you could speak to, Mr. Axelson?
Yes, generally there is a factor used. So 1 cubic yard, depending on the density of the material, will generally equal anywhere from 1.3 to 1.5 tons of material. So there's an escalating factor. My understanding is, most landfills actually weigh the trucks coming in, so they'll get an actual tonnage being disposed from that individual delivery.
Okay, thank you very much.
You're welcome.
Other questions, commissioners? Okay, seeing none, Ms. Rosenberg, do you want to call your next witness?
Yes, we would like to call Mr. Jeremy Farron.
You guys hear me?
Mr. Farron on the panel. Audio check, Mr. Farron?
Yep, I can hear you. Can you hear me?
We can, thanks.
So I just need to note that my neighbor seems to be mowing his lawn, so I apologize if you hear some noise.
And one moment, I'm having those same bizarre technical difficulties here.
Let's hold the time for a sec. No joke intended.
All right, Ms. Stafford I will question Mr. Farron, but Ms. Stafford is going to share her screen because I'm not able to do that right now.
Yes.
So thank you, Ms. Okay, thank you.
Bring in the potty seat,
Do you want to bring a potty seat with you and stools?
or do you not need it?
Dr.
Someone
Murphy,
is not muted right now who maybe wants to be muted. But I think we're good. Thank you, Mr. Farron. And as you know, the commission has heard you testify several times today, but did you do anything different today relative to what you did yesterday to prepare for testifying?
I reviewed some materials specific to this matter last night and this morning.
Okay, thank you. I just have a few questions for you. Can you touch on why staff used the start date of when KPK started to spread the EMP waste at the spread field versus say when staff confirmed that the table 910 standards were exceeded?
Yeah, so as I understand KPK's argument, they're advocating for that later date when the laboratory results came in. And while we needed the lab reports to confirm some violation, the impacts had already been identified. We talked about Mr. Gintadas' inspection of that location, multiple dump truck loads of EMP waste. The horse was out of the barn, and we really didn't need to wait for the vet to tell us it was a horse.
Right, thank you. And then can you touch a little bit more on how staff calculated the end date for the environmental violations?
Yeah, so Dr. Gintadas talked about that as well. It's true, and Mr. Mueller was kind of driving at this, that they did commence some corrective actions. But remember, the phrase is commence corrective action to the director's satisfaction. I believe staff selected a recent inspection where there were no corrective actions. So what's going on out there was, sorry, I'm blanking on the right word, but was satisfactory to staff. And so that's the end date that we selected there. Work is still ongoing. And Dr. Gintadas mentioned that there's still some work to be done. There needs to be some additional sampling and confirmation, and then remediation of that location. So although the work has commenced to our satisfaction, it's certainly not done.
Thank you. And can you describe, did staff consider reclassifying 324 Big A into a Class 2 violation?
We did, but yet again, that's a rule that's been classified and in place, and I don't believe it's been ever reclassified. So we stuck with the class 3.
And then what about reclassifying the impacts as being moderate or minor versus major?
You know, I believe we've heard some testimony from both Mr. Axelson and Dr. Cantadas that they believe this was a significant impact. Given the size, you know, the nature of this waste, you know, if multiple dump, you know, hundreds of dump truck loads of soil is not a significant adverse impact, I honestly don't know what could be.
And then did you consider consolidating rules 324 big A and 907?
We did, but 324 is directed at sort of the environmental impact side of what happened here, and 907 is really the EMP waste side of things. So in our mind, they're distinct violations.
All right, thank you. I have no further questions for you.
Mr. Mueller, Cross?
Thank you. Sorry, my mouse wasn't cooperating. Mr. Farron, just a couple of questions. On the first day that you testified, and you testified with regard to the commencement of remediation activities to the satisfaction of the commission, you said, as I recalled your words, and I tried to write them down, once there's action in the field and they've begun sort of mobilizing to address the problem and begun the remediation process, typically that's when you accept that the activity has commenced to your satisfaction. Do you remember that testimony?
I don't remember using those words, but I believe that that's generally the case. It wasn't here though.
And yet, if they were stockpiling soil and had begun the process that was going to culminate in remedying the problem, and the biggest part of that remedy I would submit is removing those, you know, however many 4,000 tons of dirt from the premises. That was the biggest thing that had to happen, and they started that as early as September of 2020.
Yeah, so it needed to be stockpiled and then removed, right? So there was multiple steps there that took months. So, you know, like I said, that was not satisfactory until we got additional action and additional information.
The regulation does use the word commence, though, doesn't it?
I agree. And I also mentioned that it's still ongoing.
Well, what is ongoing? As I understand it, KPK has been asked to grab samples from an area, surface water samples from an area that is presently dry. Is that one of the pieces of work that's still going on?
I don't know the details more than Dr. Gontadas, but yeah, as I understand it, work is still ongoing.
You would agree that we can't collect surface water samples when there's no surface water?
I assume so, but I'm not.
Objection, Mr. Farron is not qualified to answer questions about what happens in the field.
I think you underestimate it. All in good fun, Mr. Farron. So you don't know what else remains to be done. If I tell you the other thing that remains is just the results of the analyses of the soil samples that were conducted of the native soil after the after the removed soil had been taken to a landfill. We're still waiting for those lab analyses. Are you aware of anything else that remains to be done to close out this site?
I'm not. I think Dr. Gontadas talked about that sampling piece that you just mentioned.
Very well. I don't have any further questions for Mr. Farron.
Thank you, and I don't have any redirect.
Okay. Commissioners, looking to you to see if anyone has questions. All right, seeing no questions, Mr. Farron, you're excused. Ms. Rosenberg, do you have other witnesses?
No witnesses, just a small closing.
Very good. Let's hear the small closing.
Sure, thank you. Thank you, commissioners, for taking time to listen to this matter. The testimony, the documents, and the stipulated facts found at pages 3 to 5 of the parties' filed stipulated facts have established that with regard to Rule 907A, KPK did not properly handle their EMP waste when they hauled their NESU 1 oily waste to the field behind their office. With regard to Rule 324 Big A, KPK's actions of dumping 300 dump trucks of exploration and production waste into a field near wetlands and water caused significant adverse environmental impacts that lasted for months. And with regard to rules 907E1 and 908B, the parties stipulated that KPK did not seek or obtain pre-approval to dump the EMP waste in the field behind their office, and the field is not an appropriate facility to dump the EMP waste. While KPK denies that it violated these rules, the evidence is undisputed that they did. And this is a very simple case. KPK violated these rules. Thank you.
Thank you, Ms. Rosenberg. With that, I am going to suggest we take our morning break before we get going with the defendant's case. It seems like we're about 10 minutes early, but let's go ahead and take our break, and let's return at let's say 10:55. Just like 12 minutes. Mr. Mueller, do you want to start with your case?
Thank you, Mr. Chairman. We are happy to do that. I'm watching to see my witnesses appear in the conference room. These will be the first witnesses from our side today, so I don't know if they have to be admitted as a participant from that conference room or how that works.
I think we've got the conference room admitted now. Let's see if we can get their screen turned on.
Just click on this button. It's not. Okay.
Here we go. Mr. Chairman, then if you're ready, I'll proceed with our first witness.
We are ready. Go ahead. Thank you.
Good morning, Mr. Knopp. Thank you for joining us today. Can you hear me all right?
Yeah, can you hear me?
Yes, thank you. We've come to know you pretty well, but just give us the quick version. You are the you're the environmental manager at KPK?
That's correct.
And you were involved with the response to what has come to be known as the soil spread field location when it first became a location. Is that correct?
That's correct.
Well, how did it get its name, by the way?
That was, I don't know if there was a term developed for that yet. I believe Dr. Gontautis just applied that for simplicity for reference.
And so, Mr. Knopp, can you tell me how it came to be that you first were out there with inspectors from the COGCC?
Yeah, so a complaint was filed regarding the location. Following the complaint, Dr. Gontautis provided notification that he'd be out within 24 hours to assess and perform sampling. And so that was kind of the notification that, first of all, I was notified of that location, and so I met Dr. Gontautis out that following day, and Ms. Brown as well.
Who was the second person? I'm sorry.
I'm sorry, is Ms. Carr Brown?
Okay. She's with COGCC. She's staff.
Mm-hmm. That's correct.
So you met at the site. There'd been a complaint. What was the nature of the complaint?
I believe it was in reference to the soil being brought back to that location.
And everybody knows this, but this soil had been delivered there from the NESU 1 site a few weeks prior to the complaint being lodged. Is that correct?
That's correct.
And when you and Mr. Gontautis met at the site, what happened?
When we met with Peter, I'm sorry, Dr. Gontautis, he wanted to, assess, the soil there. you know, observe it, make observations. So he did the visual olfactory observations, and also wanted to collect samples for analytical analysis. So Dr. Gontalves and Ms. Brown made that sectional sampling traverse. They went down the, you know, the longest length of the location and established, you know, 50-foot intervals to collect composite samples from.
And did you follow them and take your own samples while this was going on?
Yes, after they were completed with each 50-foot interval, I followed behind them and made a composite sample from the exact points that they collected their samples from.
You said composite sample. Can you tell the commission briefly what that means?
Yeah, so instead of a single sample for one specific location, it's more of a representative sample. So for those 50-foot intervals, there was also 2 other samples laterally collected and mixed together with that center location. So together, they're mixed and collected as a composite.
And you and Mr. Gontalves both took your own set of composite samples and sent them for analysis. At some point, you received back from Mr. Gontalves the results of their analyses of the soil composites?
Yes, that's correct. Dr. Gontalves provided their results.
And you, before or after, around the same time, got your own results back. Is that correct?
That's correct.
You heard testimony this morning from Mr. Gontalves, Dr. Gontalves, that there were exceedances with regard to hydrocarbon detects at, I think he said 3 of the, maybe he said 5 of the locations. I don't want to put words in his mouth. If you recall, Max, please tell me.
Yeah, I think Dr. Gontalves mentioned 3 to 4. I believe it was 4 that were exceedances off from their samples. Our samples did not have the same results from our collected samples. Only 2 of the 9 had TPH exceedances of that 500.
Does it follow that whether it was 4 of the 9 or 2 of the 9, the others did not have exceedances for hydrocarbon?
That's correct.
Is it fair to say that the soil at the location was not uniformly in excess of the table 910 standards for hydrocarbons, although it was in certain locations?
That's correct.
Mr. Gontalves said, I think that he sampled at places where he saw staining. I hope I'm recalling that correctly. Was it your observation that that's what he did?
No, I don't believe he focused, tried to locate specific stained areas to sample. They established a measured point for sampling to collect. So that was all measured out and done specific to those measurements to make that equal traverse, I guess.
That grid did look measured rather than as if it was in pursuit or something. It wasn't random, so I agree with that. I just wanted to verify it. There was talk this morning about elevated levels of arsenic, and initially there was an indication from staff that they were going to hold us accountable for exceeding the arsenic levels. I understand that has been dropped from their complaint. Are you aware of that, Max?
Yes, that is correct. It has been dropped from the complaint.
And can you explain how that came to be and what you know about it?
I believe it was in reference to having collected a background sample from the Nessie 1 location, which the soil originated from. That background sample was collected and analyzed, and the native soil at that location was shown to have higher levels of arsenic that were equatable to the levels shown from the samples from the spread field.
So if I'm following you, in the natural context of that environment, the arsenic was not out of whack.
No, it was representative of where we brought the soil from.
There was testimony this morning, Mr. Knopp, about the cost of hauling material to, I think it's Front Range landfill or disposal site. I think the number that I think it was Mr. Axelson used was in the range of $50 to $70 per ton, I guess. Does that comport with your experience? Is that what would it cost to haul soil?
No, that's incorrect. Our fee for the Front Range landfill is $18 a ton. So that number was inflated at least 3 times.
Mr. Axelson computed a number of something like $340,000 that would have cost us. But his figure was 3 or 4 times higher than the actual $18 a ton that we pay. Correct?
Yeah, I think you could readjust that analysis based on an $18 per ton fee, which is what we pay.
So I went to law school because I can't do math, and I'm not going to try to do it, but it's not accurate to say that KPK stood to save itself, $340,000 by not landfilling that material. It would have been considerably less that they would have saved.
Yeah, that number is not correct.
Mr. Knopp, did KPK haul the soil from Nesu 1 to the soil spread fields in order to save the cost of sending it to a landfill?
No.
In fact, was KPK moved to transfer the soil as an accommodation to the landowner at Nesu 1, or for other reasons like that?
Yeah, the landowner expressed he wanted the stockpile removed as quickly as possible.
There were costs involved in removing it from Nesu 1 to your facility. Just the trucking costs would have set KPK back some amount of money, correct?
Yeah, there was a significant amount of resources, specifically trucking, dedicated to the removal of that soil.
At the end of the day, what happened with that soil? We all know, but tell us please what you ended up doing.
It was ultimately hauled from the Nesu 1 location and brought to the location now referred to as the soil spread field.
So KPK first moved it from Nesu 1 to the soil spread field, spread it around, had to spread it back together again, and then pay to haul it and dispose of it at the disposal site, correct?
Yeah, that's correct.
You didn't come out ahead in this proposition in any way, did KPK?
No, at the end of the day, it was disposed of and the invoice was paid for the disposal.
On top of that, you are now facing allegations that could culminate in substantial fines for this activity. Is that correct?
That's correct.
This was a mistake that KPK made and wishes it hadn't. Is that correct, Max?
That's correct.
How do you think KPK would manage situations like this in the future?
Well, I think we've learned a lot from this process. I think whatever the intended use for any stockpile material, and specifically when it's being segregated between impacted and non-impacted, that communication needs to be provided to the commission for their review and comments and how to move forward with our plan. We don't have no intention of repeating this issue. And so moving forward, we hope not to be in this situation.
This property is near a KPK facility in the Fort Lupton area, more or less. Is that correct?
Yeah, just to the south is KPK's field offices.
And I think we had testimony about this, but can you verify whose property this is?
The property for where the soil was located is privately owned by the Kaufmans.
When you hauled the soil from Nesu to the spread field area, did you engage at least some outside truckers to do the work?
Yes, in order to expedite the removal, third-party truckers were brought in.
And when you removed it from spread field area to the disposal area, did you also engage outside contractors and truckers?
That's correct.
There was testimony yesterday about, well, I think it might have been from you, that at least historically KPK has liked to use its own workforce to do these kinds of things. It's the case these days, is it not, though, that you increasingly rely on outside vendors?
That is correct. We try to handle things to the maximum extent practicable, but sometimes third-party resources are necessary.
And indeed, in response to requests from staff and from the commission, you use people like Mike Haddle from time to time to assist with the remediation projects?
Yes, we commonly use Mike Haddle for that assistance.
We heard from Mike yesterday that he had done work at Nesu 1. Did he also do work at the soil spread field location?
Yes, he did. He was contracted to perform the groundwater sampling as well as the surface water sampling.
What's the status of the sampling that has been or remains to be done at the spread field location before you've done everything on your task list?
So our last bit, we just received results, the background results that Dr. Conductivity had mentioned were pending. So we need to review those. We have collected the surface water sampling that was collected on June 29th. So that information will, after review, hopefully can be submitted and provided to the COGCC with a Form 27.
Did somebody on your staff sample the field itself after the soil had been removed?
Yes, that's Jeff Ricard.
Okay. And I'm sorry, I may have misunderstood you. Are you awaiting those samples?
Yeah, those are the background samples.
Okay.
The results were just received.
Why do you call them background samples?
Because it's a, I guess it's a correct word, a showing of, what the native soils are representative of. It's a background reference for the confirmation samples that were collected in the known area of the spread field location.
And is there other sampling that has to be done that involves surface water?
I don't believe so. I mean, we need to submit the results of the surface water sampling to the COGCC, and it's pending their review.
So have you been able to get surface water samples and send them for analysis?
Yes, we have the results back for that. We're hoping to send that with the background samples, that information. So we have the results from the surface water sampling.
Okay. And then finally, can you just explain what it was that you engaged Mr. Haddle to do? I know that the groundwater sampling was one of those tasks. Was there something else that he did at the site to verify conditions?
Oh, we had also asked him to perform the surface water sampling, but during his probing activities and groundwater sample collection, he noted that all the surface water locations were dry at the time, so he was unable to do that.
And he did groundwater sampling along the perimeter of the field, is that correct?
Along the perimeter and a center location as well.
And how did those samples come back?
They were all in compliance.
Fair to say then that there was no indication in the groundwater of any impact from the soil that had been on the surface for a period of months?
That's correct.
Chairman, I don't have any further questions at this time.
Thank you, Mr. Mueller. Cross-examination, Ms. Rosenberg?
Just a few. Good morning, Mr. Knott.
Good morning.
What is your training in collecting composite samples?
Field experience, work experience, previously being a consultant, and just working with different remediation projects that involve sample collection activities.
At what depth in the soil did you take the samples on June 30th, 2020?
Is that the collection date with Dr. Gontalves?
Yes.
Those were collected, I believe, around 6 inches within the known range of the soil that was brought from location.
And you mentioned that Dr. Gontalves did not seek out the stained areas when he was collecting the samples. Is that correct?
Yeah, I was saying that he wasn't trying to collect a sample of stained soil.
So there was stained soil, is that right?
Yeah, there was. Yeah, as he said, there was observations of some areas that had staining.
Thank you. And you said the arsenic was representative of the NESU #1 native soils. Were the hydrocarbons in the soil representative of the NESU 1 native soils?
No, there was when the background samples were collected, there was no hydrocarbon present. Yeah, I don't think you could say it would be a proper background sample if hydrocarbons were present.
Okay, thank you. And you said Mr. Axelson's estimate, his numbers with the hauling amounts, that was incorrect, correct?
That's correct.
And were you aware that this information he provided was obtained from the Front Range Landfill website today?
I believe he mentioned that. I think he said, I don't know if he mentioned that he had just collected that information, but.
Did you check the rates today?
That information is from one of our recently received invoices.
Oh, when was that invoice received?
It was recent. I don't know the date.
Thanks. Do you have a contract with the Front Range Landfill? Does KPK have a contract?
Yes.
Did it have a contract in spring 2020? In the relevant times, did KPK have a contract with Front Range Landfill?
Yes.
Do you know if that modifies the rate?
I do not.
So you might get a reduced rate?
You might.
Sure.
But for us, I don't know.
What was KPK's initial plan to do with the soil at the spread field?
I believe the plan was just to leave it as is because it was viewed as unimpacted.
And then you mentioned that you would do things differently now. Why?
Basically from this process that we've gone through, and obviously the importance of having that communication with the COGCC, and they can provide their insight and guidance and establish proper ways to make a determination for if the soil is impacted or not.
Using the word proper, do you think what KPK did was improper?
At the time, no, but highlighted in the preferences of how the COGCC wants these processes done. Yes.
And does reclamation still need to be completed at the spread field location?
I believe that would be up to the landowners.
You don't think that COGCC rules govern that?
I would have to double check that.
And what do the landowners say?
I'm not sure.
Have you talked to them?
We're not at that point for reclamation activities.
Okay, so you've not even gotten there yet. Is it now considered an oil and gas facility? The soil spread field, excuse me?
No.
It's not?
I mean, it was defined as a facility because of its the filing of the Form 19 and 27.
And then don't the COGCC reclamation rules govern that then?
Again, I have to double check.
Thank you. I have no further questions. Thank you.
Redirect, Mr. Mueller.
Redirect. Ms. Rosenberg asked you about your intent. with regard to this site. Was it ever intended that this site would become a centralized E&P waste management facility, Mr. Knopp?
No, there was no intent to do any treatment.
And you don't intend, well, do you intend now and here forward to use it as a centralized E&P waste management facility?
No.
Thank you, Mr. Chairman. I don't have any further questions.
Commissioners, Commissioner Nanjapa.
Thank you, Mr. Chair. Just a quick, maybe a little bit of a global question. Is there a compliance officer within KPK or somebody who's assigned to kind of understand the rules?
Yeah, that would be my responsibilities.
Okay. And are you clear on the role of COGCC with respect to activities as an operator?
Yeah, I believe so.
Okay, and so before conducting any sort of activity, what is your practice with respect to understanding the rules?
I believe it's having knowledge of the rules and requirements and implementing those with the field activities.
Is that something that occurs while those activities are happening or prior to, or what is your sort of process for ensuring compliance?
I don't think it's a dynamic process. I think the rules are established and they can be applied prior to commencing activities.
I don't mean the application of the rules. I mean, what is your process in ensuring that you are compliant, that KPK is compliant?
It's just a process of reviewing the rules, knowing the requirements, and establishing proper procedures and policies in place that, you know, our activities are compliant with the rules.
Okay, thank you.
Other questions from commissioners? Commissioner McGowan?
Thank you, Mr. Chair. Thank you, Mr. Knopp, for your testimony. I'm curious to know, I want to make sure I understand correctly. Was the idea to put the soil on that property, but then bring it back to Nesu when it was ready to be backfilled, put back into the ground because you didn't think it was contaminated? Or was that soil going to stay permanently on the KPK site?
I believe it was going to be staying permanent at that location. There was no intention to bring it back because the landowner had requested the specific topsoil backfill.
But I think that you had testified earlier that you couldn't possibly provide that much topsoil, correct?
That's correct. We didn't actually backfill that entire excavation with topsoil. We used and filled there for majority of it, and then I believe it was at least 3 feet in depth of topsoil completed the remainder of the backfill.
So if you thought that soil was not contaminated, why wouldn't you just use that soil and leave it on site or bring it back and backfill? Where did you get the other soil that you used to fill it in? Why didn't you just use that soil?
The landowner didn't want that backfilled, and we were just working with the landowner.
Okay. As part of KPK's activities, has KPK ever operated its own E&P waste management facility? Or would this be the first attempt? So you have other E&P waste facilities?
We have one, yes.
Did you get a permit for it?
We acquired the facility that already had a permit in place.
What do you require before people are allowed to put things in that E&P waste management facility?
It's just specific to our usage, but we're required to document, you know, what's being brought to the location.
And typically, might that involve sending samples to a lab to ensure that it meets all the requirements for putting waste into an E&P management facility?
Yeah, it's specific, right? The type of contamination being brought to our waste facility, it has to be specific to hydrocarbon impacted soil within that definition.
And have you ever deposited soil at that EMP waste facility? Why didn't you use the EMP waste facility that you currently own and operate instead of putting it in the field behind KPK?
It's in Walden.
Sorry, could you say that again?
It's in Walden. It's not geographically beneficial to transport that much material to Walden.
Okay, thank you.
Commissioner Messner.
Thank you, Mr. Chair. I just need to clarify a couple things here. I think, Mr. Knopp, you indicated that there was a water sample that was taken on June 29th that you still haven't submitted for results, or you're waiting on results, or?
We have the results. I don't believe we submitted them to the COGCC yet.
Okay. So there was a water sample that was taken that just hasn't been submitted yet, and so that's your responsibility. Yeah,
we knew there was still the requirement. Dr. Conductivity had highlighted that to collect a water sample. And we were consistently checking the status of the pond. Was one of the approved sample locations to the south, and then also an irrigation ditch to the north. Both have been dry on frequent reviews, and then once it was observed that water was running or present, then we sampled.
And then I think you indicated that Dr. Gintanas took a background sample from the Nassau site. I think he had testified that all of his background samples had come from the soil spread field site or outside of the site itself.
No, I never.
At some point, I just want clarification on that because those are conflicting things.
Yeah, well, it's conflicting. I didn't say it. Dr. Gintanas never took a background sample from the Nassau site. I did that.
You did that, so he did not.
No, he had requested it.
Okay. And then just to follow up on Commissioner Najapa's line of questioning, as a regulatory compliance director, environmental compliance director, I think you're indicating that you know the rules, you review the rules, that's your professional responsibility to know the rules. Why did you not follow the rules in regards to how you were supposed to dispose of these particular materials that was indicated on the Form 19?
At the time, we believe we were in compliance with the rules. It wasn't our intention to violate the rules. It was.
But you knew that the rules clearly indicated that you needed to follow the conditions of approval that were associated with Form 19, correct?
Yes, that's correct.
And so compliance with that rule would have meant that you properly disposed of all of these materials in the landfill. Is that correct?
That's correct.
Okay, thank you.
Other questions from commissioners? Okay, seeing none, Mr. Mueller, do you have any redirect for this witness following commissioner questions?
Yes, thank you. Mr. Chairman, just a quick one. Commissioner Messner was asking why you didn't comply with the Form 19 at the Nessu 1 site. I just want to make sure your answer is clear. Did you intend to violate Form 19 when you sent what you thought was clean soil to the soil spreads location?
No, there was no intent for violation, and that I know they have the wording, and the wording is the wording that all excavated soil will be disposed of, but that was also not a typo, but an improper input of information. Our typical information we input is all impacted material will be disposed of at a certified disposal material. So,
understood. I'm sorry. You understood that you were to take impacted material to a landfill. You understood as well that you could take non-impacted soil and treat it as non-impacted soil.
That's correct.
No further questions, Mr. Chairman, from this witness, from me.
Okay, great. Do you want to call your next witness?
Yes, Mr. Chairman, we would now like to call Jeff Peterson. Mr. Peterson, thanks for joining us again. I think everybody is familiar with you. You are the head of the roustabout crew. You were working at the Nassau 1 site and helped remove the soil that we thought was not impacted at that site to the soil spread field location in the vicinity of your shop near Fort Lupton. Is that correct?
Yes, sir, that's correct.
Was I correct in saying earlier that you used outside trucks as well as some of your own trucks to transfer that soil in the first place?
Yes, sir, we did.
And also then when that soil was removed again and sent to the disposal site, you used outside trucking firms to assist with that?
Yes, sir.
And is it the case, Mr. Peterson, that KPK uses outside vendors and maybe indeed is using them more now than it has in the past?
Yes, sir, that's correct.
So the soil gets delivered to the soil spread field location. Can you describe your involvement in that and what happened to the soil once it was delivered?
When the soil began to arrive, we had a dozer that was out in that field or in the Kaufman field. We began knocking down those piles in order to make it easier for the trucks to come in. With the amount of trucks coming in, it was getting, I guess you could say, crowded. So we began to you know, spread the dirt out and to make it a little easier for the trucks to arrive.
And once it was spread out, it became your task then to collect it back into a pile so that it could be removed from the site. Is that correct?
Yes, sir.
And did you oversee that operation?
Yes, sir, I did.
Do you remember, as a general proposition, when that collection, that stockpiling began?
I believe sometime in September of, I believe 2020, I believe.
If I told you that it was September 10 of 2020, would you have any reason to disagree with me?
No, sir, I would not have a reason to disagree.
You have somebody on your staff, and indeed, who might be able to help us button down that date. Is that correct?
Yes, sir. Our production manager, Manuel Silva, would be able to button that down.
As far as you knew when that soil was removed to the spread field location, Mr. Peterson, you and everybody else, well, you believed that it was unimpacted soil. Is that correct?
We believe that, yes. I believe that, yes.
Did you intend to operate a centralized waste management facility at that spread field location once you got the soil there?
No, sir.
You had tested buckets full of soil as it was being excavated at the Nassau location in some fashion, correct?
Yes, sir.
Remind us how you did that.
Through visual inspection, if we saw any staining, we would put that in the impacted pile, the contaminated soil, or if we smelled anything funny. Through our process, what we felt was clean dirt that we were excavating out. If we did not see any signs or smell anything, we then took our PID meter and we grabbed samples from that bucket as it was coming out, and we tested it with that PID meter. And then if we didn't read anything over 50, we would put that in our clean pile.
In retrospect, and in the future, would you agree it would be better for KPK to conduct lab analyses of soils before making a decision such as the one you made to transfer that soil from Nesu to the spread field?
Very much so.
Did KPK benefit in some fashion from removing it to the spread field instead of testing it and sending it to a disposal site if that's what was indicated?
No, sir, there was no benefit to us at all.
Mr. Chairman, I don't have any more questions for this witness.
Cross-examination, Ms. Rosenberg?
No questions for this witness. Thank you.
Questions from commissioners? Commissioner McGowan?
Thank you, Mr. Chair. Thank you, Mr. Peterson. Have you taken soil to E&P waste facilities other than the Nassau location for KPK?
Yes, ma'am. Yes, we have taken soils there before.
And did those soils require lab analysis first?
No, we did not require lab analysis for those. We knew that it was contaminated by sight and smell.
So never mind. I'm good. Thank you.
Other questions? All right, Mr. Mueller, I believe we can release Mr. Peterson at this time, and we can move to your next witness.
Well, one question for you, Mr. Chairman. We might be able to skip the second to the last witness because it may be that he's really going to just look at one piece of paper which specifies the date when the collection of the soil began. It's out of his day timer. I think that Mr. Peterson may be familiar enough with this that he could do it and we'd save a little bit of time.
That's fine.
Okay, so let's give that a try.
Share your screen?
Sure I do.
Very good.
Mr. Peterson, you and I have looked at this, and also Manny Silva, who's part of your crew. It comes out of Manny Silva's day timer for the year 2020. And as we've been told by Mr. Silva, these are the notes he takes at the beginning of the day when they gather to go out to the field and take on tasks. And in the 10 o'clock time slot under Thursday, September 10, he has a note that says Angelo, and that points to the box above. But beneath that, it says, well, if you can read it, would you please do so, Mr. Peterson?
Yes, it says Marcos with a dash and then yard spread field.
So in as much as crews were going to go out and start work, what does that notation tell you about what was going to happen at the spread field?
That tells me that I was going to dispatch Marcos, our heavy equipment operator, and a dozer to begin work on the spread field.
And what kind of work was he going to do?
He was going to be scraping that up and piling that up.
We know he was going to be scraping it up, not spreading it around, because by now it was already spread. It was already the subject of an enforcement proceeding. And this was, as far as we know, the beginning of the collection process to remove it to the disposal site?
Yes, sir, that's correct.
I have no further questions for this witness on this subject.
Ms. Rosenberg, do you have any cross on this issue?
No, I don't. I do have one question. I'm sorry, Mr. Mueller. Is this for which matter is this listed as an exhibit? I remember seeing this, but I'm not seeing it on the attachment A. But I could be missing it.
So it's marked Exhibit II.
Okay, thank you. Yeah, I know. Thank you.
Ms. Rosenberg, have you found it? Because I think it was a rebuttal.
Yes, thank you. I did find it. Thank you.
Now, Mr. Chairman, I'm happy if you would like to dismiss Mr. Peterson.
Yes, we can dismiss Mr. Peterson and bring your next witness on board.
Chairman, we would like to call Mike Haddle. Good morning, Mr. Haddle. Thank you for joining us. Can you hear me?
Yes, I can.
I should say thank you for joining us again. You were with us yesterday as well. Can you remind the commission who you are?
Mike Haddle, owner and operator of Apex Consulting Services, Inc., subcontractor for KPK Kaufman.
Mr. Haddle, you appeared in regard to the Nesu 1 site where you had done some sampling after the excavation was complete to verify that the contamination had been removed. Did you do some sampling and analysis as well at the soil spread field location?
Yes, I was contracted to collect collect groundwater samples from the spread filled area and to also attempt to collect surface samples from the lake and the discharge ditch creek below the lake or pond located to the southwest.
And tell me then about that sampling and how much of it you completed and what it revealed.
Initially, the morning that the work commenced, I installed 5 temporary groundwater monitoring wells and with a geoprobe rig similar to what we used at Nesu 1. After the completion of those wells, I collected groundwater samples from each of the wells. Thereafter, the temporary wells were removed, the PVC casing, and they were backfilled with bentonite and hydrated, and the surface was matched to what was there before we arrived.
So are you seeing my shared screen, Mr. Haddle?
Yes.
Is this the geoprobe rig that you were describing?
Yes, it is.
And this, you got groundwater samples, correct?
That is correct.
And did you also take soil samples?
I observed the cores out of each of the temporary monitoring wells. That's a photo of the cores to document if I observed any discoloration, any indications of petroleum contamination, and I screened the soils with a PID for volatile organic vapors, and none of the aforementioned were present in any of the cores from any of the monitoring wells.
Is this an accurate picture of what the field was looking like after the removed soil had been removed and sent to the disposal?
Yes. I had never seen the spread field prior to that day, and that's how it was on, I believe that's March 10th, 2021.
And did you, so I think I have a map. Am I showing you the right map, Mr. Haddle?
Yes, you are.
Can you tell
Each
us?
of those blue circles is the location from which I completed the temporary monitoring well.
When you say blue circles, there's a blue circle with a little X through it.
Yes, pardon me. They're the blue circles with the X's are the exterior borings that were requested at the perimeter of the spread field. And then the solid blue circle that's kind of in the middle of that spread field is the 5th boring. So there's 4 at the perimeter and 1 at the center of the spread field.
That's the one without the X.
That is correct.
And is this the map that, it looks like it's the same map that I guess Mr. Quintanas was using previously?
Yes.
So it shows his red sampling locations as well.
I believe so.
And there was testimony that this came some period of time before the spread field. It may not depict what the spread field looked like when you were there.
That is correct.
There's a blue arrow that points to the northwest. Do you see that?
Yes.
Can you tell me what that is?
I believe that is what is to believe the direction of groundwater flow.
The bottom of the picture shows a pond and a sensitive wetland area. Are you telling me that the groundwater flow is away from those locations?
Yes. I didn't prepare that map, but my guess is that they determined based on topography that that's where they believe the groundwater flow would be.
So you didn't put that arrow there?
No, sir.
You have your own opinion about which way the groundwater flows?
I probably would say I concur with what that arrow depicts. I have not done any map analysis, any data analysis, but it seems reasonable to me.
Did you take this picture as well?
Yes, I did.
And can you tell us what this is?
That's the ditch creek. It's what is located below the pond that would transfer water from the pond to the ditch that is located several hundred feet north of the spread field.
You were trying to find surface water to sample, is that correct?
That is correct, and I walked most of that area, and groundwater, or pardon me, surface water was not apparent in any of the locations.
You tried more than once to find surface water to sample, am I right?
That is correct. Periodically in April and May, if I was doing other work for KPK, I would stop by, drive onto the area, look for water, and then if there would have been water, I would have reported it to Max and said, okay, we can now sample.
In addition to being up gradient from the flow of the groundwater, is it the case that just in terms of the terrain, this is somewhat uphill from the spread field as well?
I'm not sure if it's uphill. It may be at the same elevation. It is definitely down gradient of the pond.
Is the pond up gradient from the spread field?
I believe it is.
Do you know then if surface water samples have finally been collected?
It is my understanding that KPK personnel collected surface water samples sometime in late June, within a short time frame after it became apparent that there was water present in the pond and in that drainage area.
And Mr. Howell, you do various projects for KPK, remediation related work and so forth. Is that correct?
That is correct.
You're not employed except as a consultant or a contractor by them. Is that correct?
That is correct.
Mr. Chairman, I don't have any further questions for Mr. Howell.
Ms. Rosenberg, do you have cross?
I believe just two questions for you. So you didn't take any samples from the spread field location in summer 2020, correct?
That is correct.
And in March 2021, did you know what corrective actions the COGCC was requiring KPK to complete?
No, ma'am. I was requested to collect surface and groundwater samples, and that's what I attempted to do.
Thank you. No further questions.
Sorry, I have a follow-up. It's just one I should have asked, but I think it would be a benefit to the commission. With your permission, Mr. Chairman.
Go ahead.
Mr. Hattle, groundwater samples have come back. Do you know if the analyses have come back?
Oh, yes, on the groundwater samples, the 5 samples were analyzed and we're all in with compliance.
Yeah, I should have asked you that. If I didn't, my apologies. That's with regard to the groundwater samples.
That is correct.
No further questions, Mr. Chairman.
Ms. Rosenberg, any redirect on that issue? Or recross, sorry.
No recross, thank you.
Okay, with that, I think we can let this witness be excused. Oh, sorry, you're right. Priya and John have questions. Go ahead. Commissioner Messner.
Thank you, Mr. Chair. I just wanted to make sure that, again, I'm understanding some of the presentation that was given. Mr. Hattle, correct?
Yes.
Mr. Hattle. So I think what I heard you testify a lot about was the way that water is flowing on this particular site and directions that it's flowing and different topography associated with this site. Were you asked to do an analysis on that? Is that part of your expertise and what you were asked to do on this particular site, or are you just speculating?
I was asked during this testimony to opine on what I thought that arrow on that map was, and I was asked to opine on whether I believe that the pond is up gradient or down gradient of the spread field, and based on my site visit, I rendered my opinion that the pond was up gradient of the spread field, and I concurred based on just looking at that map with the arrow that groundwater flow can potentially be to the northeast as that arrow indicated.
Okay. I mean, I'm pretty used to reading maps and pretty hard to tell which way things go without topographic features on the maps. And so I guess I was just struggling a little bit to understand how you would do that analysis on a Google Earth doc.
I was basing that based on my field observations on the day that I performed the installation of the temporary groundwater monitoring wells.
Okay, thanks.
Commissioner Najapa.
Mr. Chair, and thank you, Mr. Hattle, for your testimony. Just a quick question. Do I understand correctly that you have extensive expertise with the use of PIDs with the work that you do?
That is correct.
And we heard from other witnesses that the PIDs are more for volatilized compounds, and you also mentioned VOCs is what you were looking for. Is that correct?
That is correct.
Okay. And do you understand, or we heard that there are certain types of hydrocarbons that are not volatilized, like especially with a heavier petroleum compound. Is that your understanding as well?
That is my understanding. Although they can often have some response on a meter, on a PID. Even the heavier materials can sometimes, you can sometimes get a response.
Okay, but is it your understanding that if there were heavier crudes or other petroleums that were not volatilized, that those could be present but not detected on the PID?
That is possible.
Okay, thank you.
Further questions?
None from me, Mr. Chairman.
Okay, very good. Do you want to call your next witness?
I assume I'm free to go.
You're free to go.
Mr. Haddle, we appreciate your service.
Thank you, Mr. Haddle.
Thank you.
Thanks, Mike. I think our next witness is the young Mr. Satterley.
Well, again, not a witness, but
Sorry.
thank you, Kirk. I'll once again be speaking on the penalties that were calculated for this NOAV. So first, there are two duration adjustments that KPK believes need to be accounted for. KPK maintains that the penalty start date should have been when the impacts or perceived threat of such impacts were first identified or confirmed, which is when staff reported the analytical results of the composite soil sampling that showed exceedances of a few Table 910 constituents on August 10th of 2020. Now, as for the end date, this should have been in early September of 2020, specifically September 10th, 2020. Not in late June of 2021, as staff contends. As we went through on Tuesday for the UPRR NOAV, Rule 525 states that daily penalties will stop accruing when corrective action is commenced, not when corrective action has concluded. Yes, the phrase "to the director's satisfaction" is in the rule, but any ordinary understanding of the term commence cannot be interpreted to mean when corrective action is complete. This rule states that commencing corrective action might involve activities necessary to assess and evaluate whether there are potential impacts or other near-term actions to stop, contain, or control such potential impacts. The penalty policy expands on this by noting that the time required for long-term actions necessary to fully and completely remediate any identified impacts are ordinarily not counted as part of the penalty calculation. And the policy further illustrates this concept by stating that the penalty clock should stop ticking when material is stored in a way that abates the potential threat of impacts, which in this instance occurred when KPK commenced safely stockpiling the soil spread field soil in early September of 2020. So in its pre-hearing statement, staff is attempting to tack on an additional 8 to 9 months of penalty calculations than what is allowed by the rule. Now, staff has also mischaracterized this as a Class 3 major violation, but at most, it should be a Class 2 moderate violation. Class 3 violations present significant probability of adverse impacts, and the facts show that nothing here rose to the level of being significant. In addition, this should be reclassified from a major to a moderate violation at most, as staff has no evidence that the incident had any actual significant adverse impacts to human health or the environment, which, as you know by now, is the standard for major violations. By contrast, a moderate violation occurs when there is a threat of a significant adverse impact or a moderate actual adverse impact. Now, first of all, KPK owns the spread field property, and property ownership is itself an institutional control such that KPK was able to control any potential exposure to human health receptors on its own property. As for environmental impact, staff relies on visual observations of some standing, albeit without photo documentation, smell, and composite soil sampling that showed slight exceedances of a few Table 910 constituents. While this might arguably go to impact or perceived threat of impact, none of it constitutes sufficient evidence of significant or major actual impacts. Staff also points out the proximity of the spread field's location to certain water bodies in the area. However, the fact that the spread field was located within so many yards of a water body does not in and of itself establish that an actual significant adverse impact has occurred. At most, this goes to staff's beliefs that the incident may have presented a threat of impact, which, as you know, is the criteria for a moderate, not major violation. Therefore, like the UPRR NOAV, staff has failed to meet its burden to show that a major violation has occurred in this instance. I'll also note that KPK contends that the same duration adjustments and reclassification principles I just mentioned apply to not just the Rule 324 violation, but several of the other rule violations alleged in this NOAV. But I'll direct the commissioners to Exhibit 000 for a detailed analysis of each. Okay, the next thing I'll point out is that the penalty policy provides that remediation costs can be considered as a penalty adjustment factor when the cost of remediation exceeds any economic benefit to the operator of noncompliance, as well as the penalty to be assessed. Here, KPK ultimately obtained no net economic benefit from what transpired, as the cost incurred by KPK to address staff's required corrective actions clearly exceed the penalty requested. As for the Rule 907A violation, because the facts alleged for this violation are not substantially distinguishable from what is alleged for the Rule 324 violation, staff should have consolidated or dropped one of the duplicative violations. As in accordance with the penalty policy, asserting a full penalty for separate rule violations arising from a single event would result in a penalty that is disproportionately large. Here, the NOAV alleges the exact same facts and corrective actions for both of these rules violations, and both are assessed a separate large penalty for the exact same time period. These same consolidation principles are also relevant to the 907E violation, which staff has assessed the exact same penalty amount as it did for the Rule 907 violation, for the exact same facts as all of the alleged violations in this matter. And therefore, staff should have consolidated these duplicative penalties of nearly $360,000 each. Thanks, and that concludes KPK's presentation for this NOAV.
Thank you, Mr. Satterley. Looking to see if any commissioners have questions. All right, seeing none, I believe that that NOAV on soil spread field 4024-94406 is submitted.
Chairman Robinson, I apologize for this. In addition to Mr. Satterley's closing, we may have one additional closing comment to make. I don't know if it's necessary, but I would ask if we could have until after the lunch break to decide if we have additional closing to make.
Yeah, that's fine. I just took Mr. Satterley up on his word that he said that you'd closed. So we will break for lunch now. We will come back at 12:50. And at that time, if you decide that you want to use some of your time for additional closing, you can do so.
Thank you very much.
See everybody at 12:50. Okay, welcome back, everybody. 12:56, and I think we're going to try to reconvene. Good, there's Mr. Mueller. We'll wait for Mr. Jacobs. We need Ms. Rosenberg as well, I think. You're muted.
I apologize. Ms. Stafford will be handling this matter for staff. Sorry.
Okay. You might want to stick around, though, because I think we might be talking process and times and things as well. So I know, Mr. Mueller, you potentially want to have some additional closing. Did you guys decide if you want to do that?
We have decided, and we are going to let Lucas be our closer. We won't ask for any further closing. Thank you.
Okay, so you're good. All right, and then so the next question is, do the two sides want to talk process dates, et cetera, for the remaining 3 NOAVs at this time, or do you want to wait until the end of the day?
We can talk about that now. John Jacobs for KPK, Mr. Chairman.
Okay, very good. Do you guys want to lead in with what you're thinking? I have polled all the commissioners, and Ms. Larson has their availability over the next couple of weeks. So what are you thinking?
If I may, Ms. Stafford had proposed 3 dates to us late yesterday, and we conferred and bumped calendars. She proposed the 19th, 20th, and 23rd of August, next Thursday, Friday, and the following Monday. We have some conflicts on the 19th, and that will not be possible. We can do the 20th and the 23rd, and I think that might be sufficient for the 3 NOAVs. However, Mr. Haddle, who is one of our witnesses, as you know, has limited availability. He would need to go on the 20th, Friday, a week from tomorrow, because he will actually be in the field for KPK installing some groundwater monitoring wells. And we'd very much like him to continue to do that important work, as I expect staff would as well. But that means he would need to testify for Grant Tank Battery on Friday. So we'd like to propose the order of Grant Tank Battery, Charter Schneider, and then concluding with Wagner number 1, if that's acceptable to the chairman and to staff, of course.
What about Ms. Stafford? How does that work for you and your team?
Your audio seems to have cut out for me, at least, Mr. Chairman.
Thanks, Mr. Jacobs. Ms. Stafford, how does that work for you and your team?
Thank you, Chair Robbins. That should work pretty well for our team. I will add that the 18th just recently became available for staff as well. Actually, just one moment. So we would also have, some witness availability issues on the 20th, but I believe that particular witness will only be testifying on the 19th if we move in the order that Mr. Jacobs proposes, which I believe was potentially the order that we had originally set forth when we started talking about splitting the NOAVs out.
Ms. Stafford, just so I'm clear, I believe Mr. Jacobs said they would not be available on the 19th. So at this point, we're proposing the 20th and the 23rd.
The 20th and the 23rd should be okay. We might ask that, I believe it's Mr. Axelson who's not available on the 20th. So if any testimony he might need to give, if we could push that to the 23rd.
Do you anticipate he would need to testify in the Grant and the Schneider NOAVs?
Those are 2 potential matters he could testify in, yes.
And there's nothing to preclude, I mean, could
going
you take,
back.
Yeah, going back and just not closing the record in order to accommodate the witness?
True. Yeah. Is the 24th available for the parties?
Double checking, but I believe so for us.
And Mr. Jacobs, while you're looking, if you could also look to see if the 18th is available, because I believe Ms. Stafford, you noted that that day has now opened up for staff.
Ms. Larson, unfortunately, one of our, Ms. Rosenberg is not available on the 24th.
Oh, she's not available on the 24th. Okay.
That's right.
Okay. Would she be doing all 3 NOAVs?
No, she will be handling the Grant Tank NOAV.
And if we scheduled that first, would you be uncomfortable if she would not be able to participate on the 24th?
Let me confer with, or maybe Ms. Rosenberg can unmute, and I am comfortable with that. If I just want to make sure that she is also comfortable.
I'm sorry. I was checking.
Comfortable. I just really can't actively participate that day, but I could be generally available that day.
Thank you.
This is the 24th?
That would be the 24th, the Tuesday.
Okay. As far as I can tell, August 18, 20, and 23 are available.
So now that brings the 18 into play.
It does, and that might actually be better. So just taking a step back, for the 3 NOAVs that remain after we close out these 5, Grant, Schneider, Wagner, we could start on the 18th, not have anything on the 19th, that Thursday, come back on Friday the 20th, and conclude on the 23rd. And that would, we anticipate that we should be able to run through the NOAVs on that Thursday and Friday, recognizing that Mr. Axelson may not be available.
Wednesday and Friday.
Thank you. Wednesday
Yes.
and Friday. Recognizing that Mr. Axelson is not available on the 20th, so we would endeavor to hopefully get most of his testimony in on the 18th. Whatever we're not able to get in on the 18th and he's not available on the 20th, we can come back on Monday the 23rd. And then we would have the 23rd also for deliberations among commissioners.
That schedule would work for staff, I believe. I'm seeing, yep, I think, yep, that would work. Thank you.
Okay.
Likewise for KPK. Thank you.
And obviously, is that okay with the commissioner schedules?
It is. And if I have misread an email from a commissioner, please raise your hand and let me know if you're not available on the 18th, the 20th, or the 23rd. Not seeing anything.
Okay, so do you want to have the hearing officer solidify that into an amended pre-hearing order?
Yes, we will get that done.
And we'll get that sent around, make sure
Yes.
we've got it right for everybody.
Yes. And Mr. Chair, just to confirm, have we confirmed that we're reconvening on Monday to finalize, have commissioner deliberations?
I think that's what we agreed to yesterday.
Okay.
As we're doing closing arguments, statute of limitation, oral argument
Tomorrow.
tomorrow, followed by a potential executive session for legal advice.
Correct.
And then we'll take the afternoon to start working through our notes.
Okay.
Okay, anything further, Mr. Jacobs?
Yes. Thank you, Mr. Chairman. I believe it's the bridge that we waited to cross. We've arrived at in the nature of confidential business information being protected and what procedures we might entertain should there be questions that require reference to that information. And as you recall, I described how one of our rebuttal exhibits, an expert report, has been submitted through the e-filing system and identified, but in redacted form to protect confidential business information. And so I wanted to again revisit that subject and discuss the procedures for protecting that information, but allowing the commissioners to get the information they need to deliberate and find what they will.
Yes, we are aware of this. Glad that you brought it back up ahead of the potential hearing, and AAG Davenport magically shows up because I think he's developed a solution for us.
Great, thank you.
Thank you, Mr. Chair. Mr. Jacobs, so I think we have developed a process for it, first of all. I just want to clarify, maybe I was confused the first time around. Are you intending to have definitively a part of your rebuttal case to ask this witness questions about confidential business information? Or is
No.
it, sorry, go ahead.
No, I do not. We can have our witnesses, Mr. Weiss, and prior to Mr. Weiss, the firm's chief financial officer, Mr. Stoltz, testify without getting into the redacted portions of Mr. Weiss' report.
Okay, thank you. So this would be in the event that the commissioners wish to ask your witnesses questions about that redacted or unredacted version.
Commissioners or staff's counsel.
Okay, all right. Ms. Stafford or Ms. Rosenberg, do you know if you would like to ask KPK's witness about that confidential business information?
Or about the unredacted portion of the confidential business information?
Right.
I don't believe it's our intent to question their witnesses about that particular exhibit at this point. So no.
Okay. Then at this point, it looks like it would just be only in the case of commissioner questions, and I doubt the commissioners all know if they're going to ask questions yet. So maybe we can figure that out in the future. The procedure that I believe we can do is actually an executive session through the open meetings law, specifically 24/6, 402, 3A Roman 3 would allow the commission to enter into executive session for the purpose of asking questions about, and this is a quote from the statute, matters required to be kept confidential by federal law or rules or state statutes.
Very good.
So, and Mr. Jacobs, you and your co-counsel could attend that, obviously, and sit in and listen to the whole thing. Same thing, AAG Stafford, you could also attend that, I think. And everyone could be there. It would be an executive session. It would be not a public hearing in that case. I would like to see, without obviously discussing the confidential information, I think Mr. Jacobs and Mr. Mueller, I would like to see some offer of proof before we go into that executive session, an explanation of why this meets something that is confidential under federal regulations, federal rules, or state statutes. So we do have something on the record to demonstrate that it is appropriate to go into executive session for it. You can point to something that's already in the record, then that works for me as well, I think.
I appreciate the question, if I may, Mr. Chairman.
Yeah, go ahead.
I think I understand you to be asking us to simply point to how the exceptions to public disclosure under CORA, Colorado Open Records Act, are satisfied by the production of this kind of sensitive financial information regarding the respondent, KP Kaufman Company, Inc. Is that what you're asking for?
That would work, or any other state statute or federal law that requires that information be kept confidential.
I think that's the most straightforward, Mr. Davenport. Thank you.
Okay. So should it become necessary, I would, if the commission indicates a desire to question KPK's witnesses about information that's been designated as confidential, I would ask KPK's counsel to make that offer of proof using CORA, it sounds like. Then we would go into an executive session using the standard executive session script that I read. I don't believe, given that it's going to come up on the fly, we don't need to put it into the agenda, Ms. Larson, as long as we read it on the record what the topic of executive session is going to be. And then we would need to go into a different Zoom, I believe, based on our past practice, where all the parties and the witnesses could attend and the commissioners, and that examination would be done in private in that executive session.
Is that satisfactory, Mr. Jacobs?
Yes, I believe so. We'll endeavor to have the language that Mr. Davenport has requested referencing the exception to public disclosure under CORA at the ready later this afternoon, in case commissioner questions require reference to that confidential business information. Thank you.
Ms. Larson, just so that we're not waiting around, why don't we go ahead and schedule that executive session for, say, 3 o'clock, and then we'll have on everybody's calendar a Zoom link, and if we need to go into it, we can do that now, or we can do that at the appropriate time.
Certainly, we can do that.
Ms. Stafford, from your perspective, does that all sound appropriate if it's necessary?
Thanks, Chair Robbins. I do believe that sounds appropriate if necessary.
Okay. Do any commissioners have any questions about the process that's been identified? Okay. Very good. Anything further on process before we move into the charter? No. What are we doing? We're doing the Gillison number 5 flow line.
Anything further from KPK, Mr. Chairman?
And nothing further from staff. Thank you.
Okay. Then, Ms. Stafford, you are recognized to begin the presentation on Gillison number 5 flow line NOVA AV number 402-571-143.
Thank you, Mr. Chair. I will now share my screen. And can everyone see that and hear me?
Yes.
Okay, great. Good afternoon, Commissioners. AAG Caitlin Stafford on behalf of Commission staff. In the fifth and last NOAV before you at this stage, you will learn about the Gilson number 5 flow line. Much like the NOAVs we have discussed here previously, this is another situation where a landowner had to file a complaint with COGCC in order to get the spill on the agency's radar. Commissioners, there are already agreed upon facts in the parties' joint stipulated facts that get staff close to proving these violations. Regarding Rule 906B, page 20 of the stipulated facts includes the parties' agreement that yes, KPK failed to provide COGCC with notice within 24 hours of the release, failed to notify the proper emergency authorities within 24 hours of the spill, failed to provide a supplemental report on the spill within 10 days of the spill, and failed to provide verbal notification to the landowner within 24 hours of the spill, as the owner actually notified KPK of the release. The only point KPK disputes in this matter is whether this was a reportable spill. And our evidence and testimony will show that more likely than not, this was a reportable spill. Our evidence will also show, more likely than not, KPK violated Rule 906C2, and for clarification again, I am referring to the rules in effect prior to January 15th of this year. Rule 906C2, when it did not make good faith efforts to consult with the affected surface owner prior to commencing operations to remediate and clean up the spill. And now I would like to call staff's first witness, Mr. Chris Canfield.
Can you all hear me?
Yes, we can.
Excellent. Thank you.
Good afternoon, Mr. Canfield. So I don't believe you've testified before the commission yet here in this phase of the proceeding. So I'd like to ask you some introductory questions. Would you please introduce yourself to the commission and provide your title here?
Yes, my name is Chris Canfield. I'm a COGCC Environmental Protection Specialist.
Thank you, Mr. Canfield. And about how long would you say you've been at the COGCC?
I joined the agency in 2006. From 2006 through 2013, I was working at the agency's office in Rifle, Colorado. In 2013, I was reassigned to the Denver office, where I've worked ever since. Currently, my areas of responsibility include Boulder, Broomfield, and Denver counties, as well as portions of Arapahoe, Adams, and Weld counties.
Sorry. Thank you, Mr. Canfield. I was having an issue with my PowerPoint there. Now, Mr. Canfield, could you briefly describe to the commission what your job entails?
Yes, indeed. Primarily, it entails the review of our Form 19s, which are the spill release reports, and Form 27s, the site investigation and remediation work plans. I review related documents submitted by operators, respond to complaints we receive. My work involves field inspections in addition to desktop reviews. I also interact with operators, with their consultants, with surface property owners, and with local governments.
Mr. Canfield, you mentioned working on remediations and specifically Forms 27. So could you tell me generally what that aspect of your job entails, just a little more specific than you have been?
Certainly. Our process begins with an operator submitting an initial Form 27, which I will review, and at that point, basically I'm looking to see if it is complete if the information provided is correct. I'm sorry.
I'm sorry, I almost interrupted you. Go ahead.
That's okay. Occasionally such forms are approved by me as submitted, but it's not uncommon that I will apply review comments and conditions of approval. Once an operator submits, actually once they have an approved plan and begin to implement the approved plan, they will submit supplemental Form 27s to keep the COGCC appraised of their progress, to amend the approved work plan if revision or amendments become necessary, and ultimately to request from us a determination of no further action being required on the project. It's a highly iterative process. I've heard it described by prior witnesses as a running dialogue between us and the operator. That's a good way of putting it. There is no set number of supplemental reports, and as well, the duration of individual projects will vary in response to the complexity of those projects.
Thank you, Mr. Canfield. Now, I'd like to turn to the specifics here a little bit more, and I'm going to try to set the stage here. And again, this is a demonstrative exhibit I've put up. I've pulled this information from various sources that are in the record. As council may see, I've pulled this information from the joint stipulated facts as well as exhibits 503 and 508. Now, Mr. Canfield, can you tell me a little bit about the Gilson location? What is going on there?
So the Gilson location is a small farm, working farm. It's actually located within the municipal boundaries of Frederick, Colorado. It's just to the west of I-25 and to the south of Godding Hollow Parkway. Godding Hollow Parkway being one of the two primary east-west roads traversing Frederick.
I'm going to advance the slide deck here, and this is again another demonstrative that we have showing a basic overview of the site, not necessarily intended to show exact site conditions on the day, but to reorient people. So could you explain to me where Godding Hollow Parkway is on this map? Is it this road that goes left to right?
Yes, you've correctly identified it.
Okay. And could you tell me where the location of the spill is that we're talking about?
It is it's basically outlined with that red polygon in the center
right
of the
here?
map. Yes.
Okay. And there are some other outlines on this map. Could you tell me what else we're seeing in this picture, please?
The red polygon is in the upper right-hand corner of a pasture, which is part of the Gilson property. I see delineated in white running along basically from north to south along the eastern side of the pasture. That's a constructed water feature. It's the Boulder Weld County ditch.
And Mr. Canfield, is my mouse hovering over this ditch generally? That's what you're speaking of?
Yes,
okay,
you're tracing
so
the ditch, yes.
Okay, thank you very much. Please continue.
That's basically it. So you're looking at a small working farm within Frederick, west of I-25, just south of Godding Hollow. And the Boulder County, Weld County ditch passes through it.
Thank you, Mr. Canfield. And this is part of your area of responsibility?
Yes, it is.
And and how many times have you been out there?
I've been there multiple times. Twice I was there to conduct inspections. On other occasions, my work took me past it. I was on my way to inspect other projects or meet with operators, basically at locations to the west of what you see in your figure. And so I'd be driving by it on my way to and from those meetings.
Thank you, Mr. Canfield. Now, I'd like to turn to the, oh, I'm sorry.
I apologize for interrupting. It's hard in this environment. But I wonder if you just tell me what that exhibit number is, please.
We took this overview map from exhibit number 5. I do note that you had objected to the admission of that particular exhibit. However, we're using it as a demonstrative here in order to show the commission the general area that we are dealing with.
All right, thank you.
Thank you. Now, Mr. Canfield, I'd like to turn to the specific events that are described in the NOAV. So can you tell me when you became involved with this matter?
Yes, I became involved in this matter on October the 13th of 2020, at which time the property owner submitted a complaint to us.
Okay. And could you briefly describe that complaint?
The property owner alleged in their complaint that they had discovered an active gas leak on July the 15th of 2020. It was not clear to them initially what operator, as there are several operators in the vicinity, it was not clear to them which operator might be responsible for the line that was leaking. What I learned from the property owner is that they had contacted, in addition to KP Kaufman, they had reached out to 2 other operators. All 3 operators sent representatives to look at this. And the property owner tells me that it was the KPK representative who acknowledged that his employer was responsible and that they would be taking appropriate action to deal with the release.
Now, Mr. Canfield, when did you say you learned this information again?
So the complaint was received on October 13th of 2020. It was assigned to me that same day.
And
I was not able to.
Oh, I'm sorry.
I was not able to speak directly with the complainant, with the property owner, until the next morning, October 14th. So not.
Is everything okay?
Yeah, I'm sorry. Everything just went black on my end.
We can still see you.
If I could have a moment or two, please, I see nothing.
Chair
Why don't we
Robbins, if
take a break just for a second, let the witness get reoriented with his computer and screen. Mr. Canfield, just FYI, we can still see you and we can hear you.
That's good to know. My concern is, at this time, my computer monitors are both blank. And as
so
a result, I will not be able to
exhibit.
see any of the
Yeah.
exhibits that are shown to me.
Do you want to take a couple of minutes and maybe reboot?
Yes, sir. If that would be allowed, yes.
Yes,
I think
that
it
is
would be
allowed.
the best thing to do. Otherwise, I'm flying blind.
No, Ms. Stafford, I assume that it's important for him to be able to see your screen.
it is, Chair Robbins, I will be showing some exhibits
Okay,
just here.
Let's take a break until 1:30. It's 1:26. And that'll give Mr. Canfield a chance to reboot and everybody else can just sit back for a sec.
Thank you.
Is the witness back in the room or first off, I don't see him on the panel. Is he in the attendee list?
I am.
Sorry, Mr. Chair, for interrupting Ms. Larson there. I don't see him, and I believe he might need an additional minute or two.
Okay, that's fine. I just I was just commenting offline how we've only had one technical glitch. That's pretty amazing so far for a multi-day hearing. I'm monitoring the C's because he is Chris Canfield. There, he looks like he's joined us. So let's see if we can make him a panelist and see if we have him. Mr. Canfield, if you can hear me, we can see you. Well, we can't see you, but yep, now we can. We see you.
Pardon me 1 second here. I've got a couple more things to.
Looks like you went down in the basement.
I am. Man, whatever it takes here to make this happen. Down in an unfinished room in my basement now, and we will make this go.
Tell me when you're ready. Ms. Stafford, do you want to share your screen again and we can make sure the witness can see the exhibit?
Thank you for the reminder, Chair Robbins.
Okay, I believe I'm ready to go. Whoa. Good, I see your screen too. Perfect.
You can see the map? Okay.
Yes, sir.
All right, then let's turn the timer back on and we will get started again.
Thank you so much for your patience, and thank you, Mr. Canfield, for alerting us to your technical issues.
Sorry about the interruption.
We understand. So we were before we had to stop, we were discussing your description of what you learned from the complaint. So if I could back up with you a little bit to get back to that spot.
Certainly.
You mentioned you received the complaint on October 13th, 2020?
That is correct. The complaint was assigned to me on October 13th of 2020.
Now, after you visited the location and spoke with the landowner, did you learn anything else about this particular complaint?
Yes, again, the landowner explained how they had discovered an active gas leak, what they described as an active gas leak. They were not sure which company might be involved. They walked to 3 nearby producing wells to get emergency contact info from the well signs. They called all 3 of the companies, KP Kaufman being one of those companies, and all 3 companies sent representatives. It was the KP Kaufman person who acknowledged to the landowner that their company was responsible for the leak and that they would be dealing with it. They would be taking action on it.
Thank you, Mr. Canfield. And following your initial investigation of the complaint, who did you contact after that initial investigation?
So my initial investigation involved or resulted in me entering an inspection, and the inspection had corrective actions, including one requiring KP Kaufman to submit a Form 19, to notify the municipal government and to coordinate with the surface owner.
Thank you, Mr. Canfield. And I think what I was getting at is between that any of that time, did you learn any other additional information from the landowner?
Yes, I did. What I learned from the landowner is that, again, they had discovered the gas leak on July the 15th. They had met with Representative KP Kaufman on July the 15th. They were told that the problem would be dealt with. The landowner explained, so they allege in their complaint, so they told me in subsequent communication that they made clear this was a working farm, this was a pasture. I believe the pasture is used to graze horses. And they wanted to know when work would take place and if they would be getting some prior notice, some advance notice, so that livestock could be moved to an alternate location. They were told on July 15th that, and again, this is an allegation made within their complaint. I was not a party to that conversation, but the property owner alleges that they were told the repairs to the line would happen soon and that, yes, there would be contact alerting them prior to people and equipment showing up to make those repairs. There was
Mr. Chairman, I'm not going to officially object, but I think I should note for the record that much of this is in the nature of hearsay, and you've admitted hearsay previously, and I understand that the commission is advised to let that go to the weight of the evidence, not the admissibility. But we are hearing a narrative through Mr. Canfield of a witness who is not present for us to examine. I just want to note that for the record.
Yeah, I actually appreciate that, Mr. Mueller, and commissioners are reminded about all the things Mr. Mueller just said. It's similar to what I would have said if you had objected. So continue, Mr. Canfield.
So again, I want to be clear. I'm basically just reiterating the allegations in the complaint I received, and I will make clear when I'm not reiterating the complaint, but telling you what I learned in a face-to-face conversation with the property owner. In such a face-to-face conversation, I was informed that the property owner, over the course of approximately 6 weeks, starting July 15th, 2020, and I believe up until August 24th, 2020, the property owner had heard nothing from KP Kaufman. The property owner had made multiple attempts to contact KP Kaufman by phone and by email, and just again hoping to understand what the timing would be for repairing the line, which had the well had been shut in, the line had been depressurized, so the leak was not ongoing, but they wanted to know when the repairs would be taking place.
Thank you, Mr. Canfield. That was very helpful. I would like the commission to take note of that August 24th date as we go forward. It will become more apparent why that plays a role in some of the allegations here. Now, Mr. Canfield, I'd like to move on and discuss with you the specific violations at issue in this NOAV. And what I have up here is Rule 906B, and that is, again, prior Rule 906B, which was in effect before January 15th of this year. Can you see that?
Yes, I can.
And could you tell me your understanding of what the purpose of this rule is?
The purpose is prompt, timely notification, not just to the COGCC, but to the local government, so that appropriate action can be taken. In the case of a local government, something adjacent to one of their streets, they it's not atypical, unusual if they would require some sort of traffic control if equipment and vehicles being used in the response were entering and leaving the street from something other than a driveway or an intersecting road. In our case, timely notification affords our staff an opportunity to get out and see conditions that, in this matter, I know basically through the surface owner's allegations. Much of what they were alleging had happened months before I received the complaint, before I learned of the spill. And so there's a corresponding delay in my ability to get out there and make observations, collect samples for laboratory analysis, if that's appropriate, and so on.
Thank you, Mr. Canfield. And now you mentioned you went out to the location on October 14th. I'm going to advance the slide deck here, and I believe I'm showing what staff marked as Exhibit 503. Do you see that?
Yes, I do see it.
And now these pictures here, did you take those?
Yes, I did. They are part of the initial inspection I made.
And at least for the picture on the right, is that what you saw when you arrived on site?
That is a sign that's depicting where a line crosses a road, where it crosses Godding Hollow Parkway.
Oh, I apologize. I meant the picture on the left, if I didn't say that correctly. Does that accurately depict the site?
Yes, on that day.
And did you see anything else at the site when you arrived that day?
The fence along the northern edge of the pasture had been taken down to enable access to where you see the excavation.
So when you arrived, so what you're saying is when you arrived, there was no fence around that excavation there?
There was a section of, I'm going to say something on the order of 150 feet more or less had been taken down to allow vehicles to access this, what you see in the photo, from Godding Hollow Parkway.
Understood. So that's something that's not depicted in this picture?
No.
Okay, thanks. So I'm going to move on and ask you a little bit about the potential spiller release that was at issue here. Now, based on your observations when you got to the site, was this considered a reportable spiller release?
Yes, in my opinion, it was.
And why is that?
It's a release occurring outside of any secondary containment. It's a release that is, the spill release point is and I'm very sorry, my monitors had gone out again. Oh, I'm back. I apologize for the technical glitches. So outside of secondary containment, not on the road or shoulder, but adjacent to it, the excavation you're looking at ultimately was, well, for me, it was 3 strides from the edge of the road to the edge of the excavation, relatively close to the previously mentioned Boulder County, Weld County ditch. I measured the distance, the separation of 38 feet. Again, the property owner was concerned about their livestock, their horses. That's really what triggered the complaint. Is at the time the complaint was submitted to us, the fence had been down, the excavation had been open for over 2 months. And during that time, the property owner wasn't using the pasture.
Thank you, Mr. Canfield. And to back up quickly, you know, I believe I'm just going to bring the slide deck back here. Some of the language in Rule 906B talks about a public byway. What is a public byway? Would that just be a road?
Well, I believe it would be a road that the public could access as opposed to a private farm road or ranch road that might be behind a fence or a closed or locked gate. Again, Gauding Hollow Parkway is one of two major east-west roads crossing Frederick.
Thanks, Mr. Canfield. So I'm going to move forward a couple of slides here. We've already seen this one. And I've pulled up what staff marked as Exhibit 508. Can you see that? I understand some of it might be a little small.
Yes, I can see it.
And can you tell me what this document is?
This is a Form 19 initial spill release report.
And this is this the Form 19 that KPK filed after you visited the site?
Yes, this was filed to satisfy the corrective action that was applied to my inspection.
And now I'm not sure if you can see my cursor here, but I'm reading here that flow line release occurred on July 15th, 2020. So, and also on this initial Form 19, KPK reported, quote, no liquids were released. So what type of flow line was this?
This is a flow line. It's probably a better question for my colleagues in our engineering integrity unit, but I do believe it was primarily used to transmit gas.
So, and when KPK said that no liquids were released, so what was the spill, I guess, or release that you understood to have happened?
So what the property owner described was a release of natural gas. The property owner further alleged in their complaint that they had observed what they described as contaminated soils being removed. Again, there is a significant gap between when that allegedly happened and when I was able to conduct an inspection. By the time I got there, there were no spoil piles. The excavation had been open for roughly 2 months. And as a result, the walls of that excavation, the floor of the excavation had been exposed to the atmosphere and sunlight for an extended period of time. I couldn't verify that part of the allegation.
Thank you, Mr. Canfield. And just generally, commissioners, I'd like you to point you to the pages 19 and 20 of the parties stipulated facts. We have various facts that both sides have agreed to here that clearly set forth at least the duration of the violation that we're alleging. And we also heard a discussion from Mr. Canfield about an August 24th, 2020 date where the excavation, I guess, supposedly began here. So I just wanted to direct the commissioners to that. And I will move forth with my last question to Mr. Canfield. So here, what sort of impacts did the failure to report this spill have? Can you tell me a little bit about the environmental impacts here?
Primary impact would have been to the owner of the property. They lost the use of their pasture from mid-July until sometime in December, I believe the second week of December. Threatened impacts to the Gauding Hollow Parkway into the Boulder and Weld County ditch. I know from talking directly with the Weld County Carbon Valley Emergency Management Agency that had they been aware that this work was taking place, they would have required some sort of a traffic plan. They most definitely would not have closed the lane on Gauding Hollow Parkway, but they would have required signs and possibly a flagger to notify motorists of vehicles entering and leaving the road from an unexpected spot.
Thank you, Mr. Canfield. I'd like to move on to the other violation alleged in this particular NOV, which is prior rule 906C2. Can you see that up on my screen?
Yes.
And now, can you just tell me generally, very briefly, what your understanding of the purpose of this rule is?
The rule is the rule requires an operator to make a good faith effort to communicate, to coordinate and consult with the property owner. In this situation, what I learned from the property owner is they had basically waited for 6 weeks for some action to be taken with respect to repairing the flow line. And then what action did happen, construction crew arrived unannounced and simply began taking the fence down. By the time the complaint was submitted to us in mid-October, the property owner was concerned about, at that moment was still an open excavation, the fence still being down. They ultimately would have concerns about the seed mix being used to revegetate the disturbed area. They were concerned about introducing vegetation in their pasture that they were quite genuinely interested in keeping out of the pasture.
Thank you, Mr. Canfield. And again, commissioners, I'd like to point you to pages 20 and 21 of the party stipulated facts, where there is additional information about this particular violation as alleged by staff. At this point, I don't believe I have any additional questions for Mr. Canfield.
Okay, Mr. Canfield, stand by. Mr. Mueller may have some cross-examination questions for you.
Thank you, Mr. Chairman. Canfield, you had several communications, it sounds like, with the homeowners. Are you aware of communications that the homeowners had with representatives of KPK?
Yes, I was.
Are you aware that they exchanged emails and had telephone calls on numerous occasions?
I was aware of that, but I'm not aware of the timing of all those communications. So I am aware of communication of the homeowner told me that they met in person with Avi Mailer. They told me that there were phone calls and emails, but I'm not entirely sure. They were also at the same time, the homeowner, telling me that there had been a gap initially of 6 weeks where there was no response to their phone calls and their emails.
The homeowners were eager to get this project completed and closed out, isn't that correct?
They were very eager. They wanted to regain the ability to have stock in that field.
That was their primary reason that they were calling KPK and yourself and filing a complaint. They were eager to close out this site.
Yes.
You said it was 3 strides from the, let's say that fenced area where there's a hole. It was 3 strides from there to the road?
Yeah, I'm 6'2". It took me 3 good strides to get from the borrow ditch to the edge. I'm guessing that's somewhere on the order of 10, 11, 12 feet.
You didn't measure it?
No.
You measured the other distance to the ditch, I guess it was?
Yes.
What did you use to measure that?
I used a measuring wheel that I take on inspections.
But you didn't use that wheel to measure the distance from the hole to the road?
No.
You talked about secondary containment as a reason why there might be a violation here for the Rule 906. Secondary containment is something you use when you're dealing with liquids, am I correct? Or it could be soils.
it's used with liquids, but it's not, I wouldn't limit it just to liquids.
Is there such a thing as a secondary containment for, you know, a leaking gas flow line?
No, which would be my point, that the release point, there was, once the flow line lost containment and there was an active release, there was no means of controlling it until the well was shut in and the line was depressurized.
In fact, the line was depressurized and shut in on the same day. I think that the meeting occurred on July 15th. Isn't that correct?
That's what was reported to me by KPK, yes.
So the standard under Rule 906 for a release or a spill that is that it has to threaten or impact you know, structure, livestock, a public byway, correct?
Yes, waters of the state, wildlife, and so on.
Did you determine whether this release that was stopped the same day that the representatives of the company arrived, did you determine that that was a threat to the byway?
Yes, given the fact that it was adjacent to the byway, yes.
Given that fact alone?
Yes, proximity to Godding Hollow Parkway, but also proximity to the ditch, and which was running at the time of the release, and the fact that at the time the release was discovered, the property owner was using the field.
Does it matter the size of the release?
No, I believe the rule is a narrative standard, not a numerical standard. It describes any release, any spill or release that impacts or threatens to impact such things as public byway,
so the operative,
occupied structure, waters of the state, livestock, wildlife.
The operative part of that is we know there wasn't any actual impact to these livestock or to the highway or the ditch. So the operative part of the violation was that there was a threat. And that you're right, it doesn't provide a numeric standard, but how do you make a determination whether or not a leak, be it a small one, how do you decide that it is a threat?
So I must state very clearly, I have no way, it's not possible for me to dismiss the notion that there was a threat. The spill came on COGCC radar more or less 2 months after it was discovered. There had been some action taken there, and because of the delay in reporting, I simply don't know what I would have seen had I gone out on July 15th or July 20th for that matter.
But you don't know if there was a threat there on that day or not.
Given an active release of gas from a flow line in close proximity to Godding Hollow Parkway, to the ditch, to the horses, I certainly would have perceived it as a threat. I know the property owner did.
You can understand the difficulty that KPK or anybody else might have when there is apparently a pre-existing release. They turn off the flow line immediately, and then they have to decide, well, when this happened, it was a threat or it wasn't a threat.
No, sir, I'm sorry. Given the proximity to the road, the livestock in that pasture, the proximity to the ditch, an active gas release, I would have expected KP Kaufman to notify us very quickly by phone or email following their learning of it, and I would have expected them to notify the Carbon Valley Emergency Management Agency as well.
Understood, and I appreciate it. Their obligation, though, was if it was a threat, and they were there on the scene at the time. You were not. Their determination was that it was not a threat. you can appreciate the dilemma they're in when the guidance is nothing more than a threat to an impact, and your position is, well, if it's a leak, it's a threat, period.
If they have any uncertainty, all they need to do is contact myself, John Axelson, and I can assure you, had they made that contact, our direction would have been to immediately notify the local government and to submit a Form 19. And we would have been out there probably within 24 hours to inspect the site.
You saw in your examination of and visits to the site thereafter, you didn't see any liquid releases, no E&P waste, no other kind of contamination except for the fact that there had been a release of gas.
That's correct.
The fence was taken down, and that you were given to understand was so they could access the area and make the repairs and turn off the line. Is that correct?
That is correct. That observation, I observed the fence taken down, but I also saw the tracks where vehicles were entering the property from Godding Hollow and then returning to Godding Hollow at the point where the fence was down.
So there's nothing in the notice of violation, however, suggesting damage to the property of the landowner or to their fence or injury to their livestock. None of those things are alleged in the notice of violation, are they?
I don't believe so, no.
You aware that for penalty purposes, staff has characterized this as a minor violation, the 906 B violation?
No, sir, I do not get directly involved in determination of penalties.
You've been very cooperative, Mr. Canfield. I appreciate it. I don't have any more questions.
Thank you.
Thank you, Mr. Mueller. Any redirect, Ms. Stafford?
Yes, Chair Robbins, just a question or two. Hello again, Mr. Canfield. Thanks for bearing with us here.
Thank you for bearing with me.
You're welcome. So Mr. Mueller got to this in his cross-examination of you. The threats of impact or reporting spills of similar size releases. When this happens with other operators, do you receive a report?
Yes. It would be unusual not to, very unusual. I wouldn't say it's unheard of, but it would be rare.
Thank you, Mr. Canfield. And getting to Mr. Mueller's question about surface impacts, you know, earlier we had an exhibit up showing the picture you took on site that day. And what was your observations of the site on that day? Were there surface impacts?
I didn't see any surface impacts. Any soil removed from the excavation had been removed. So I saw an open excavation, which ultimately became larger as seen in subsequent inspection photos. Could see flow lines exposed in that excavation. It was basically it. Saw the fence down, vehicle tracks.
Thank you, Mr. Canfield. I don't have any further questions for this witness.
I'm sorry, Mr. Chairman, this prompts one follow-up if you will indulge me.
Go ahead.
If other operators came across a small leak that they contained immediately and that in their estimation did not pose a threat to wildlife or roadways, you wouldn't hear about it. Isn't that so?
No, sir, I wouldn't agree with that.
Well,
I routinely get operators will contact me by phone or email, describe something happening. In part, it's a courtesy communication from them in case I receive a complaint from the landowner, or certainly something within municipal boundaries and very near a major street. They will reach out and they'll ask, should we not, or they will simply do it.
My point is you have no idea how many other operators are out there responding as KPK did, making their own determination that this is immediately fixed, no longer a threat, if it ever was a threat, and they don't report. You have no idea how many of those events happen because you don't hear about it.
That would be true. If something's not reported, unless we receive a complaint from a surface owner or are notified by a local government. But I can tell you, I've been doing this 15 years, and in my area of responsibility, what you're describing would be unusual.
Okay, I appreciate it again. Thank you very much, Mr. Canfield.
Mr. Canfield, commissioners may have questions, so bear with. Commissioner Messner.
Thank you, Mr. Chair, and thank you, Mr. Canfield, for your testimony. Along that similar line of questioning, is it fair to say that the best management practices for a responsible operator is to notify the COGCC or you as the inspector upon any spill to determine whether it's reportable or not?
I would think so. Again, what I see routinely are operators wanting to get out in front of a situation to preempt the possibility that the COGCC will learn of it via a complaint. So yes, I would agree with what you're saying.
And then another question is, just so I understand, because a gas release is different than a liquid spill or release. But when there is a gas release, particularly close to certain receptors like public byways or livestock or waters of the state, or residences as indicated in the rule, is one of the concerns combustion and explosions?
It would be one of my concerns that it could ignite.
So certainly it appears to me that that could be a fairly significant threat even for what could be perceived as a small release.
I would agree with what you're saying, Commissioner, and that was one of the concerns expressed to me by the property owner, not in their complaint, but on the occasions I met with them.
Okay, thank you.
Other questions from commissioners? Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you very much, Mr. Canfield, for your testimony. Again, following the same sort of line, as you noted, you routinely receive calls from operators just to report things that have happened. Should we, shouldn't we? How would you describe the nature of those interactions?
They are, I would describe them as informal running dialogue with operators, which sometimes leads to an operator submitting a Form 19, but not always.
Is the dialogue, is the dialogue intended to assist the operator in moving in the right direction, or are you immediately telling them that there's going to be penalties, or are you, what is the nature? Is it a friendly dialogue? Is it a, what is it typically? How does that work?
It's friendly. It's operators asking for help, for guidance, direction, asking for an opportunity to have an informal conversation prior to submitting a form. and sometimes, again, just wanting to get in front of a situation, wanting to avoid having something where it's the landowner or the local government that comes to the COGCC, not the operator. That suddenly changes the dynamic.
Right. And so when an operator contacts you and says, hey, you know, unfortunately there was this leak, this spill, this whatever, are you also letting them know that, you know, well, here's what you need to do and you'll have to submit this form. There may be a penalty, you know, those kinds of things. Are those kinds of the discussions that are discussed at that time?
So much of the discussion will focus on whether or not they need to submit a form. As far as what they're going to do, I try to avoid prescribing that, at least until I actually am in receipt of a 19 or a 27, at which point, and upon reviewing it, reviewing the information, I can apply review comments, establish conditions of approval. I also have an opportunity to take similar actions. If I inspect the site, I can assign corrective actions. But I'm basically responding to what the operator is saying to me, as opposed to trying to direct specifically what they're doing.
Okay, thank you. And so would it be fair to say that your aim upon that contact is to help guide them towards compliance?
Yes, yes, it would.
Thank you.
Commissioner Gonzalez.
Thank you, Mr. Chair. Thank you, Mr. Canfield, for your testimony. Appreciate it. I'm trying to understand kind of this kind of balance of best management practice for checking in on what may or may not be a reportable spill. And so is it just a good idea for an operator to check in and say, hey, we had this spill, not quite sure if it's reportable, not quite sure if I need a Form 19 or not? Or is it more kind of imperative that an operator contact the COGCC and say, hey, I had a spill, don't know if it needs a Form 19 or don't think it does, but I'm checking in with you anyways?
So a release from an off-location flow line such as this, typically the operator would notify us, give us the initial email or phone call within 24 hours, followed by a Form 19 initial report. You know, they would have as I would, a fairly strict reading of the rule that this is it's an off-site flow line. By definition, it's out of any sort of secondary containment. And again, as a result, it's a narrative standard, not a numerical threshold for reporting the spill.
Thank you, Mr. Canfield.
Other commissioners with questions? So, Mr. Canfield, let me just make sure I've got this right. But is it your testimony that this gas release, which is unquantified in terms of size, that because it was a gas release and it occurred adjacent, very close to the road, and it occurred in a field and therefore could be a threat to both the road and the livestock in the field, that is the reason that it is reportable under 906B1A?
Yes. Yes, it was outside of secondary containment and presented certainly initially a threat to the road, to the livestock, to the ditch.
Okay, thank you. Any redirect following questions of this witness?
Not at this time, Chair Robbins. Or no,
Okay,
excuse
Mr.
me.
Canfield, I believe you are good to go. Good luck with your internet. And
thank you.
Allow Ms. Stafford to call her next witness.
Thank you, Chair Robbins. Staff would like to call as their next and final witness on this matter, Jeremy Farron.
Good afternoon, commissioners. Can you hear me?
We can.
Great, thank you.
Good afternoon, Mr. Farron. You've been before us, I believe, in all 5 of these matters now, so we will not go through your background. Could you just remind everyone who you are, please?
Yep, Jeremy Farron, Enforcement Supervisor at the Commission.
Great, thank you. And I'm gonna just share my screen again. This is staff's calculation of the penalty, proposed penalty in this particular matter. And now I would like to just take a brief moment to acknowledge that, you know, during Mr. Canfield's testimony, he represented that there was potentially a different date to consider for ending the, I believe, the violation of 906C2, which was that when KPK showed up to the site to commence operations to remediate, he said here today, and I think this is reflected in an exhibit, that that was on August 24th, 2020, and I asked you all to take notice of that date. You know, as preparing testimony, staff is prepared to say that we are feeling confident that that would likely be a more appropriate date to end this particular violation. So for the Commission's consideration, we would at least like to acknowledge that that is also another potential end date for this violation. And Mr. Farron, I'll ask him some questions now to sort of go through the penalty calculation here. Now, Mr. Farron, have you considered KPK's argument that the violations of Rule 906 should just be 1 day?
Yeah, I believe we discussed that yesterday.
Okay, and I won't go through that examination right now. If any of the commissioners have additional questions on that, I'll leave that for them to ask to clarify. And have you discussed reclassifying the Rule 906B before?
Yeah, we've discussed that also.
And again, I believe we went through this potentially earlier. So commissioners, if you have additional questions, I would direct, I would ask you to ask Mr. Farron in the interests of time efficiency. And then Mr. Farron, what about reclassifying Rule 906C as up here?
So I don't believe we've discussed that to date. This is a new violation in this NOAV that I don't believe appeared in any of the prior NOAVs.
So what would your thoughts be there? Is this something staff should consider reclassifying?
I don't think I'll surprise anyone by saying no. You know, this was previously classified in 2015 and we haven't changed our mind.
And now, Mr. Farron, can you speak to the duration of the 906C penalty? I believe I led in a discussion, or I led in our discussion here by saying that staff is considering a different date that potentially could be appropriate in this matter.
Yeah, so the date that's presented in the claims table here is that 10/22 date. I forget the precise August date we were directing the Commission's attention to, but in actually preparing for my discussion here today, I was looking at the end date we had proposed initially and kind of comparing that to arguments from counsel, and looked at it and thought, you know what, I think that August date is more appropriate. So this is a rule that requires prior notice and communication and good faith kind of dialogue with the operator. I believe the rule says prior to commencement of remediation, and I think, I believe Ms. Stafford agrees that that August date would probably be a more appropriate end date. Looks like she's displaying that revised calculation. So we just wanted to make that game time adjustment here, if you would all indulge us.
Thank you, Mr. Farron. And yes, I have pulled up that additional window. If anybody cannot see that, please let me know. But I will, and I think I'll move on to my last 2 questions here. So Mr. Farron, were there consolidations in this particular penalty calculation?
Ms. Stafford, I'm having a little trouble viewing
Sure.
This column that you've just pulled up. Can you tell us just where it comes from?
Sure, thanks. It is my attempt to fix this penalty table on the fly up here. So if I can move this down. So this should sort of match up here. We're talking about this commission rule, the class 2 minor, which is reflected. If you can see my cursor, I will again enlarge the screen here. The daily penalty start date, which remains the same. A more conservative end date, the days of the violation. And then this 97,500 number is what the penalty calculation would be were the penalty duration matrix not applied. And then the requested penalty in this case would be the 37,250 at the last edge of the column here.
That's helpful. Thank you.
Thank you. And I apologize for not being clear on that. Now, Mr. Farron, I'll go back to the question I asked you. So were there consolidations made in this penalty calculation?
Yes, there were.
And which rules here or which violations were consolidated?
Yeah, the 906B was consolidated, and that has the effect of lowering the requested penalty.
Thank you. At this time, I don't believe I have, or I don't have further questions for Mr. Farron.
Mr. Mueller, do you have cross?
Just a couple. Mr. Farron, we appreciate the staff's adjustment of the penalties. And so I don't mean to sound ungrateful when I ask the next question. You would agree with me, wouldn't you, that if this were not a reportable event, it would not be appropriate to assess any penalties. There would not have been an obligation to do any of the things that the violation is based on. Would you agree with that?
I think I would agree with that with respect to 906B. I'd have to look more closely at 906C.
And you heard the conversation earlier with Inspector Canfield. You would agree that 906B 1 sub A, which requires the reporting of a release that threatens to impact waters or byways or livestock, suggests that not every release has to be reported, only those that actually threaten or injure, but here we're only talking about threat. There is a category that doesn't have to be reported, and that's a release that doesn't threaten livestock or byways.
I agree.
Those are all my questions.
Any redirect, Ms. Stafford?
Thank you, Chair Robbins. None. We'd have no redirect.
Okay. Commissioners, it's your time if you have any questions. Commissioner Gonzalez?
Thank you, Mr. Chair, and thank you, Mr. Farron. I apologize. You may not be the right witness to ask this, but it just kind of popped in my head. How close does a gas release have to be to a public byway to threaten it?
I'm not the person to answer that. I'm sorry.
Okay. I'll save it for another witness, I think.
Commissioner Gonzalez, as commissioners, we can certainly recall witness Canfield if you'd like to ask him that question.
Yeah, if Mr. Canfield would like to respond to that, I'd appreciate an answer to that. I'm curious.
Yeah, let's bring Mr. Canfield back on to the panel.
Before we do that, any additional questions?
Yeah, any additional questions for Mr. Farron before we do that? That's a good point, Mr. Farron. Seeing none, I think you're released, Mr. Farron, at this time.
Thank you.
Ms. Stafford, is Mr. Canfield available? Do you know?
Sorry, I was on mute. I apologize. I am checking. I think he just popped up.
I'm back.
Hi, Mr. Canfield. Thanks for sticking around. We had a commissioner question that is more directed at you than Mr. Farron, and so I'll let Commissioner Gonzalez ask his question.
Mr. Canfield, I'm sorry for bringing you back so soon, but this did not pop in my mind when you were up here. But I'm curious, how close does a gas release have to be to a public byway to threaten it?
Commissioner, I'm not aware of a numerical standard or definition. I believe that you would know it when you saw it. If I'm not aware of a number, a numerical definition or standard for it.
Okay. So I mean, in your experience, right? You know, have you seen gas leaks that are farther away from this that you assessed as not being a threat to a public byway? Closer than this? I'm just trying to understand, you know, because kind of this threat to a public byway seems to be a pivotal part of what we're trying to consider here. Just trying to understand what causes what. I mean, I understand the gas release causing a threat, but at what proximity does a gas release cause a threat? Is there any way you could even qualitatively, you know, give us an idea on that?
Qualitatively, I would say if it's located such with respect to the public byway that it could distract motorists, in my mind, that would constitute a threat.
So, I mean, so if it's within eyesight.
I don't know about
this is
eyesight.
challenging.
Again,
Green, I get.
There isn't a numerical standard. I have seen spills and releases that are manifested literally on the pavement. And I've seen other situations where the work is not on the pavement or on the shoulder, but it's close. And close can mean 10, 12 feet, and close might mean 100 feet. I'm thinking that if something is close enough that it could distract a motorist, if it's in such close proximity that vehicles being used in the response and corrective actions are going to be leaving the public road and re-entering it from something other than a typical or ordinary entrance point. It would be a qualitative thing. Again, I'm not aware of a numerical standard.
But just kind of by, I guess in your assessment, kind of by virtue of the potential for disruption to the byway via distraction or via some access off that byway to address this release or any, you know, response needed to go to this release, that would be the threat that was kind of the trigger in this case.
So I know
at least that's the public byway.
In this case, what was happening in such proximity to the road that had the municipal government or the county been aware of it, their expectation would be, again, as I mentioned, they would not require a lane to be closed, but they would have required warning signs and possibly a flagger when vehicles are leaving the road unexpectedly or re-entering the road. So if we're close enough that precautions like that are needed, I would say that would pass the test in my mind.
Okay. Yeah, I'm just trying to envision that scenario. I can envision a scenario where it could be 1,000 feet away and still they'd have to redirect the traffic coming in and off the site, you know, if that was the route that they would go to. So I'm just trying to understand, you know, at what point, you know, these spills become these threats. So I understand kind of your assessment in this regard, and I appreciate the difficulty of quantifying what I'm asking. But I think I understand what you're getting at.
Mr. Canfield, just by way of segueing off of that discussion, I think you had testified, or one of our other environmental specialists had testified. I think that Commissioner Nanjapa had asked about sort of operators checking in with regard to any potential spill to make determination of whether there needs to be a report or not. Is that practice that you have with operators? And don't answer that question yet. Mr. Jacobs has popped up.
I'm just very interested in your question, Mr. Chairman. I'm not trying to interrupt.
Okay, go ahead, Mr. Canfield.
I want to be sure I understand the question. I'm not sure I do. Are you?
I guess I'm just asking with regard to course of performance with operators in our state. If the rule is not quantitative in terms of a specific distance, rather it is you kind of know it when you see it, does that indicate to you that that a best practice for operators is to check in on every potential spill to determine whether you are believing it to be a threat or not?
There are some particularly conservative operators that do exactly that. And it does not, each and every one of those conversations does not lead to me saying, go ahead and submit a 19. But it is not at all uncommon. It's a regular occurrence for me to be contacted by operators, and they'll describe a situation. And keep in mind, the rule requires them to notify us, typically by phone or email, within 24 hours of discovery. So I get phone calls and emails telling me that something was discovered in the previous 24 hours. But asking my opinion on whether or not a Form 19 will be appropriate. Sometimes yes, sometimes no. But more often than not, what I find prudent operators doing is submitting the 19, adding it to the record. It's their opportunity to get their side of the story on the record and preempt perhaps a complaint or some sort of critical comment from a local government.
Okay, thank you. Thank you for that response. Commissioner McGowan.
Thank you, Mr. Chair. Thanks for returning, Mr. Canfield. I'm curious, was the landowner concerned about an impact or potential impact to their horses?
Yes, they were, given the fact that A, the fence was down, and B, there was an open excavation.
When they saw the spill, were they concerned about potential impact to their horses before the excavation?
Yes, they were looking at an active release of natural gas. They were concerned about the potential for it to ignite. They also realized that there would be some sort of a response. So they did not delay in moving the livestock to an alternate area.
Just to renew for the record, and I'm sorry to interrupt, Commissioner Gowan, there's been an awful lot of hearsay testimony about the concerns of the landowner. Staff had the opportunity to present the landowner. We've had this conversation, we've come out short. I understand you're tolerating hearsay, but again, this is a caution that it really needs to be weighed in the fairness of the testimony here, that we don't get a chance to talk to the landowner themselves.
I acknowledge that point, Mr. Mueller. And I remind commissioners that the landowner is not here. And so you need to judge the weight of that testimony accordingly. Okay, Ms. Stafford, do you have anything further at this point?
I just had a brief closing to close out staff's presentation, if I could be afforded a few minutes.
Please go ahead.
Thank you, Chair Robin and commissioners. The Gilson NOAV is yet another example of KPK's failures to properly notify not only the agency of a spill, but also proper emergency authorities and the landowner on work that would be performed on her property to remediate the spill. As staff has shown, the agency received a complaint regarding cleanup efforts on October 13th, 2020. Upon further investigation at the site next day, and based on conversations with the landowner, staff learned that the spill had actually occurred back on July 15th, 2020, just about 2 months prior. Yet KPK provided no notice to the agency and did not provide COGCC with the appropriate documentation to delineate the actual or threatened impacts from the spill. This was a reportable spill, and staff has proven that through the testimony, evidence, and written record. Staff has met its burden to prove the violation of Rule 906B. Were it not for the landowner losing patience with KPK's inability to communicate its plans for the open excavation on the landowner's property, the agency would not have learned of this spill. As I just stated, the landowner here filed a complaint on October 13th, 2020. And here, staff also alleged a violation of Rule 906C2, which requires an operator to communicate in good faith with a landowner prior to commencing operations to remediate. You've seen the stipulated facts, seen staff's evidence, and heard testimony. Mr. Canfield discussed the timeline here. And we know that while KPK talked about coming out to the location to begin remediation activities, they failed to notify the landowner of exactly when they would be on site to dig up her field. Staff has met its burden to prove the violation of Rule 906C2. As staff has set forth, KPK was incapable of meeting environmental reporting requirements at the Gilson location and failed to timely submit spill reporting information, making it extremely difficult for staff to identify the true, actual, or threatened impacts at the site, posing a threat of impact to the environment. They also failed to properly communicate with the landowner in this matter. Staff asks that you find KPK in violation of Rules 906B and 906C2 and impose staff's calculated penalty. Thank you.
Ms. Stafford, we don't normally have questions for you following your closing, but when you suggest the calculated penalty, is that the amended penalty?
I apologize. I hope commissioners will take into consideration both the initial and amended, and staff would set forth at this point that we would lean on the amended penalty calculation.
Thank you for that clarification. Okay, at this point, I think that we're due for our afternoon break. It's almost 2:40, so let's return at 2:55, and then we will hear from KPK. All right, welcome back, everybody. It's 2:55, and it looks like all of our commissioners are here, and that the attorneys for KPK are ready to present their case. So with that, we would allow you to move forward.
Thank you, Mr. Chairman. KPK's first witness will be Max Knopp. Hi, Max. Can you hear me?
Yes.
Thanks for joining us yet again. And we know who you are by now. We've moved on. We're talking about the Gilson 5 flow line NOAV. You were involved in responding to that. I wonder if you could start by telling us how KPK first became aware of a potential gas leak at this location.
KPK was notified by the landowner about the release on July 15th, 2020.
And when you say by the landowner, were you notified directly?
I was not. No, our land department was contacted.
And who in your land department, do you know?
That'd be Avi Mailer.
And for the commission's benefit, Avi will be testifying next, and he'll be able to talk about communications with the landowner in particular. So you learned about this on July 15. Is it correct that on that same day, the valve was turned off and flow was stopped at the location?
Yeah, upon notification, we had the lease operator immediately go to the location, assess it, determined it was associated with our line, and promptly shut in the associated well to stop the release.
Most of the commissioners probably know this, but could you expand a little bit on what a lease operator is?
They have a designated route. facilities, wells, those locations are assigned to them to manage for production purposes.
And did you have a conversation with this lease operator when you found out that the potential leak that was reported was in fact a leak? Did you talk to him or her?
Yeah, I did speak with him just to collect details about the leak, since he was the one to arrive on location, assess it, just to go over the details of it, confirm it was gas that was released, you know, and then go through the different applicable reporting criteria, you know, discuss, is it close to a byway? He did say yes. I said, what's the distance? It was estimated between 20 and 25 feet. You know, other applicable reasons, was there any fluid released? He said no. Were there any other impacts noted? No. Were there any livestock present? No. Surface water nearby? Yes. He referenced the ditch. And then those are the main criteria that I could discuss with him and make a determination of its reportability.
What was his determination about that when he characterized it for you? He answered your specific questions, but did he also offer his view of it?
Yeah, so he believed to be a minor release based on the well that is associated with that line. It's a very low pressure well, typically operating in a range of 15 to 20 PSI.
So can you create context for me? How much or how little pressure is that? Can you compare it, for example, to a car tire?
That'd be about a third, half to a third of your typical car tire pressure.
In your business, that's regarded as low flow?
That is.
And the information you received was that this was an incident minor in nature, and had it been turned off by the time you heard from him, or had the conversation with him? Yes,
his primary focus in response is to, first to assess, what's going on, the responsible line, and then make necessary corrective actions to stop the release.
You guesstimated it was about 20 feet from the road?
Yes.
I don't suppose you ever measured it?
No, I did not. That was based on information provided by the lease operator.
So once it was isolated, turned off, no longer leaking, at some point you began the process of trying to locate the leak and repair it. Is that correct?
That is correct.
There was a picture previously. I'll see if I can get it in front of us and share my screen. Can you see this?
Yes, I can see that.
Thank you. Okay, so what's going on here, please?
That's the initial excavation activity to attempt to find the flow line associated with the release. So that is excavation was done by potholing. So it's just creating that small hole to go down vertically to expose the line.
And it took a little while to get this one located. Am I correct?
Yeah, there were issues. We in this potholing investigation, we did find what we thought was the associated line, and so our initial repair attempts were centered around that discovery.
So I'm going to show you another picture. Can you tell us what that is?
Yeah, so when they potholed, this is what they discovered. There's been no work on this flow line. It was just an open-ended 3-inch fiberglass line. Based on its proximity to the release location, it was determined that this was the reason the release occurred. So repair attempts were focused at this point.
So what did you do to repair this?
A blind flange was installed on the open-ended section of the line.
And after that, did you test the line to see if you had cured the leak?
Yes, so we performed a pressure test to determine if that repair resolved the issue. That pressure test was unsuccessful based based on our records, and also Mr. Joe McLaren observed the failed pressure test. He was able to observe vapor coming out of that excavation area.
So what had happened here, Mr. Knopp?
What we found out, based on Mr. McLaren's information and my observance on site, that the gas was coming from behind the section of flow line there. So we continued excavation further back, which would be to the south. And what we found out that was just a 4-foot section of buried pipe. It had nothing to do with the installed flow line in place. And then right behind that was the actual Gilson 5 flow line that had the failed section of line.
This was an abandoned piece of pipe that was buried in this trench some while back in history, correct?
That's correct.
As a consequence of this, though, it took you some while and some period of time on the landowner's property in order to find the actual source of the leak. Is that correct?
Yeah, I mean, we had performed some field work making repairs to that initial piece of pipe discovered. And then when that was obviously not the root causes of the release, then we had to, do excavation work, re-expose the actual section of flow line, and then make repairs from there.
So, and the reason I'm asking you this is that there was some agitation by the landowners with the reason, well, they wanted their property restored immediately. It wasn't as easy as doing that because you had some difficulty locating the actual leak and some false clues along the way. Is that correct?
That's correct.
And yet the leak was discovered, reported, and sealed all on July 15. By what time had you completed the repairs out there?
I'm not sure about the flow and repair date. I would have to check. There would be a pressure test associated with that.
You were done, were you not, in December?
Yeah, the whole project was completed in December.
We had ongoing communications with representatives from COGCC, correct?
That's correct.
Who were you in communication with?
Initially, it was Mr. Canfield. He because of the complaint, he had learned more details about the release that occurred on July 15th, and got in touch with me to just discuss what had happened and in detail, what he recommended be done moving forward, and then included filing a spill report and providing proper notification to local agencies.
You also communicated with another inspector, am I correct?
From Joe McLaren? Yes.
Yes. So they were aware of the progress at the site, and you were in ongoing communication, ongoing conversation, as it were, with regard to remediating this issue?
Yeah, with the direction of Mr. Canfield, with the submittal of the initial Form 19, he had put conditions of approval, one for communication with the landowner, and also communication with the integrity management group, just to keep that communication, and then also establish a COA for a due date for Form 27.
You were directed to file a Form 19, is that correct?
Yes, from conversation with Mr. Canfield.
You had initially determined that you didn't need to do that under the rule because this was not a reportable event, correct?
Yeah, the assessment from when the release occurred in discussion with the lease operator, it was determined that it did not meet the applicability of a reportable release.
You nonetheless filed a Form 19, basically because you were directed to file a Form 19, is that right?
That's correct.
And the Form 19 requires you to check a box or more than a box just to indicate why you're filing it. What did you check?
Yeah, so in discussion, the basis before filing the Form T, it was not on the volume, the estimated volume that was released. It was with the idea that there was a potential threat to the nearby public byway.
It was not your opinion that a threat had existed, but you were complying with the direction from the inspectors, correct?
That's correct. Based on the information provided from when the release occurred, I did not believe there was a threat to the nearby byway.
There was a discussion about a fence around the field at this location and that it had been taken down. Did you have occasion to observe the fence situation out there?
Yes, I did.
And what did you observe?
So that is correct, that that section of fence had to be taken down in order for our crews to address the release location for remediation activities. As noted in the details from the release date, there were no livestock present at that location. That location does not have a continuous fence line to keep livestock. So notion of horses being in that section of area would not be possible. There's multiple openings that would not allow for containment of livestock, not associated with the section of fence that we had taken down.
So the section of fence that you took down was part of a non-continuous, partially fenced field, but not a completely fenced field.
That's correct.
Did you have any communications with the landowners directly, or was that primarily Mr. Mailer?
That was handled through Mailer, but I did communicate with Mr. Mailer about, the established COA on the approved Form 19. I mean, he already had communications ongoing with the landowner, but it was just a reminder that the COA is in place on this approved form.
Because one of the COAs was that you communicate with and keep the landowners apprised, correct?
That's correct.
In addition to filing the Form 19 as you had been directed to do by commission by staff, did you also notify Weld County?
Yeah, as part of the spill reporting process, notification to COGCC. Obviously, the surface owner is already notified about it since they were the one who notified us about it, and then Weld County, and by default, notifying Weld County, the local emergency planning committees are notified. So the Carbon Valley agency would have also been notified. It's built into the notification process.
Did Weld County take any interest in this event?
There was no communication from them.
They didn't send out flaggers?
No, they did not.
And in your investigation of the site when you first arrived and as you spent time locating the actual leak, you did not find any liquid releases?
No, there was no evidence of any liquid being released associated with the flow line release.
You didn't see any other evidence of E&P releases or substances that had to be cleaned up?
No, the only excavation work that was necessary was to be able to make repairs to the flow line. Confirmation samples that were collected showed no signs of soil impacts.
Mr. Chairman, I don't have any further questions for this witness right now.
Thank you, Mr. Mueller. Cross-examination, Ms. Stafford.
Thank you, Chair Robbins. Just a few questions. Sorry. Good afternoon again, Mr. Knopp.
Good afternoon.
So I believe you just testified about this discussion of whether or not this was a reportable spill or release. Can you tell me who makes the determination on whether this is a reportable spill or release for KPK?
That's my determination.
And did you make that determination after visiting the site?
No, I made that determination discussing the details with the lease operator.
So I guess, what sort of criteria do you use to make that assessment?
the communication with the lease operator, discussing the internal spill response procedures, detailing the information about what he's observing at the location, when he responded, why the release was occurring, how he resolved the release, impacts, if there's observable impacts, proximity to anything to, any information to collect that would make that applicability determination.
And if you could clarify this for me, that would be helpful. The lease operator, is this someone who would be trained by KPK on operating that particular lease?
Yes.
And so what sort of training with respect to spill reporting does that person have from KPK?
That's handled internally through KPK, part of our training program. It's separate from lease operation, but in terms of filling out a spill report, communicating the spill report, the details needed for a spill report, all items like that are involved with the training process.
And have any of those materials been submitted as part of this matter?
No.
Do you have records of those trainings?
Of the trainings?
Yeah.
I would have to look if we have records of the training. Of that specific.
I'm sorry.
Of the specific spill training.
Okay, and I guess, so would they get the same training as you?
No. I mean, I'm the one conducting the training, so it kind of set the, the criteria that's, presented for the training.
So if you don't mind me asking, I guess, who trained you on how to report spills?
I didn't have a professional training. I guess I had just work experience and work history working within the rules and regulations.
Okay, I'll move on to my next question here. So you've testified about this gas leak, and am I correct that you referenced it first as a potential leak?
Yeah, well, potential KPK leak, right? We were called out, like it was said earlier, they had contacted multiple operators in the area. So one would be to first assess who's responsible for the leak, or where the leak is originating from, to make the necessary corrective actions.
Okay, I understand. And then you called it a minor gas leak. Is that right?
Yes.
So there was a gas leak, right?
Yes.
A gas leak that probably released to atmosphere here?
Yeah, that's.
And a gas leak that was noticeable to the landowner here?
I'm not sure if it was noticeable to the landowner. I believe someone else reported it to the landowner.
Well, the landowner filed a report about the leak that had occurred on her property, right?
Yeah.
So there was a gas leak.
Yeah, like the information submitted in the spill report that says there was a gas leak. There was a gas leak.
Okay. And you talked a little about how it took some time to locate the Gilson 5 flow line. And that there were, I think it was phrased, and I'm sorry if I'm misquoting, there were false clues along the way. Is that close?
Yeah, that's fair.
Don't you have a flow line map to tell you where flow lines are?
Yeah, but this was close proximity to where the actual flow line was.
So I guess if you had trouble finding the flow line here, wouldn't you lean towards reporting the leak?
So I just going to object and try to clarify the record. I don't think he said they had trouble finding the flow line so much as finding the leak in the line.
We found what we thought to believe the flow line right away. There was no trouble in finding that, but it turned out not to be the correct section of flow line that was responsible for the release.
Well, I guess my question still stands there. Why not lean towards reporting the leak?
I don't see how that would correlate to needing to report the leak.
I guess I'm trying to get at here, you know, we've discussed that you potholed, you found an incorrect flow line that you thought was the leak, and then we needed to find, you needed to find exactly where the leak originated. So in knowing that you had found the incorrect line to begin with, wouldn't you then, to be cautious, potentially report this leak?
The COGC already knew about the leak by the time we established it was the incorrect section of flow line.
Okay. I guess, and then finally, you mentioned there was no fencing at the site that would have kept livestock in.
Is
that right?
It wasn't continuous to keep livestock.
Wasn't continuous. Okay. Do you know of any photos that substantiate that?
No, but you could go visit the property now and see.
But it wouldn't be indicative of site conditions on those days, right?
No, it would. Their driveway is the main open point on the fence line. There's no gate on the driveway. So as long as that driveway is still in place today.
Okay. I don't think I have any further questions.
Any redirect, Mr. Mueller?
Yes, briefly, just so it's clear. As of July 15, there was no leak because you had isolated the line and stopped the flow. Is that correct?
Yeah, that's correct.
And the question, and the reason, as I understand it, that you have been assessed a violation, it's because you didn't report the fact that until you turned it off, there had been a leak on July 15. And the question was that a reportable event? Is that how you viewed it?
Yes, that's how I view it.
And based on the information you had, you understood that it was a minor leak at best, and that it was not, therefore, something you needed to report. And in any event, you'd stop the leak. Is that correct?
That is correct.
I think that covers it. Thank you, Mr. Chairman.
Okay, that gives commissioners a chance for questions. I've got a couple to start, if that's okay. Since this case is sort of hearsay-ish because we're hearing from others speaking, I'm just trying to get a sense of what did the property, how did the property owner describe the leak, or what did your staff observe when they showed up to evaluate whether the leak was theirs? Was there hissing? Could you smell it? What was happening?
It was determined to be a minor release based on the observations made. So there was some audible detection level. There was some olfactory detection level. I don't believe there was any visual, but that was enough to confirm the leak.
Okay, and does KPK have knowledge or records as to how long the leak may have been leaking before you turned it off on July 15th?
No, we had to go based on the notification date or time.
So it could have been leaking for days or months, you just don't know.
It could have been.
Okay, thank you. I saw Commissioner Nanjapa's hand and also Commissioner McGowan in that order.
Thank you, Mr. Chair. I think Commissioner Gonzalez also had a question. So I just had a couple of things to clarify because I'm a bit confused with a couple of things you said. One, it sounded like, and I think in the pre-hearing statement, there was the notification on the 15th of July, and that there was the shut-in of the line at that time. And then there was potholing done at that time, as I understood it in the pre-hearing statement, to determine where the leak occurred. However, I believe you said that upon potholing, you discovered a line, and that the pressure test initially failed, and that Joe McLaren, the COGCC staff, observed a vapor coming out of the excavation. Can you elaborate on that?
Yes. So we potholed down.
And I'm sorry, can you tell me the dates of when that was?
I don't have the dates of the field activities.
Was this on the day that the leak was reported?
No.
So this was on the October 22nd or so date when there was an inspection out there. And at that time, there was a vapor that was observed?
I don't know the date of when Mr. McLaren observed it. I'd be able to look at records and get that for you, but.
Okay, so in other words, the line was shut in as far as you knew, but it sounds like there was some confusion as to which line was actually impacted, and that there was a point at which sometime later, because COGCC staff was not made aware of this until October 13th, and upon some sort of inspection, then Mr. McLaren was present, and you noted that he observed a vapor coming out of the excavation.
Yeah.
Is that correct? So was this a different? Go ahead.
I apologize.
I'm just trying to, was this a different leak, a different section? Was this unrelated? But obviously if there was a vapor or something like this, then this was something that was not shut in. Do I understand that correctly, or can you explain?
No, I apologize for the confusion. So when we potholed and we exposed that open-ended section of flow line, field activity centered around there. We assume that to be the root cause of the flow line release. So repairs were made to that open-ended section of flow line, right? So we installed a blind flange on that to cover the open end, thinking that would resolve it. And then we performed a pressure test. We also notified Mr. McLaren of the pressure test, which is why he stopped by. So during that pressure test, we repressurized the line with wellbore fluids, the gas. So when that line was re-energized, the gas was noted to be coming out of the excavation from behind that section of repaired line.
So this was as part of returning it back to service?
Performing the pressure test to be able to return it back to service.
So then additional repairs had to be done then on October 13th? Okay.
This was a way to, this told us that the repairs we made were not successful, and then further investigation showed it wasn't even the correct piece of pipe associated with the flow line release.
And I believe you mentioned, and thank you for that clarification. And so I believe you mentioned that this was a 3-inch fiberglass line, is that correct?
That's correct.
And what is the typical pressure in a 3-inch line?
They're low pressure, I believe less than 50 PSI.
Less than 50 PSI, okay. And from prior testimony on one of the prior NOAVs, there was discussion about the 10-inch steel pipes that were pressured at somewhere between 20 and 40 PSI. But you were mentioning that this was somewhere between 15 and 20 coming out of the line. So do I understand correctly that that could potentially be the full pressure of the line coming out?
I mean,
if a 10-inch pipe is at 20 to 40 and a 3-inch pipe is less, but you said it was 15 to 20 that was observed or was estimated by your lease operator.
Mm-hmm. Those are the operating pressures of the flow lines, whether it's a 10-inch line or a 3-inch line on our low pressure system.
Are those pressures recorded somewhere? Like, would we have a way to confirm what the normal operating pressure would be?
Yeah, that's information that's available.
Okay, thank you.
Commissioner McGowan.
So I apologize. I had questions along the same lines as Commissioner Anjapa, and I don't think I have clarity. So you can correct me if I'm wrong. You went out on July 15th in response to a complaint, heard leaking or hissing and smelled something, dug a hole where you thought the leak was, isolated, capped it off, and it it did not get turned back on until Joe McLaren came out in October?
It got turned on when we were performing the pressure test to try to verify the repair work.
That same day.
I don't know if it correlated to his inspection date, but I believe he was notified of the pressure test. So because it was a COA, it was a COA on the Form 19, to keep communication with the integrity group. So we notified him that we were going to be performing a full-on pressure test. I don't know if that was the date of his inspection of the reported release location. They could have been different events. I would have to look at the dates on that, but he was at the location when we were trying to do the pressure test. We're not bringing it back up operation. The pressure was associated with performing the pressure test, and the gas that he observed in the excavation area was because we made repairs to the incorrect section of flow line.
So I guess I'm just trying to understand, even if you got the wrong place the first time and you got the right place the second time, was it all taken care of on July 15th?
Oh, no.
No.
All these activities spanned all through until December when the whole project was completed.
I think I saw Commissioner Gonzalez first and then Commissioner Messmer.
Thanks, Chair. Thank you, Mr. Napa. I got a couple questions. I was cutting out with my internet, and so I don't know if I caught all the information around this, but you mentioned notifying the Carbon Valley Emergency Response, and I was curious when that was. I don't have that in my notes.
I would have to look back. The initial spill report was October 23rd. I forgot the date.
So it would have been in conjunction with the initial spill report as opposed to when you guys shut in the line on July 15th?
Yes.
Okay. What are the dangers associated with a gas leak, right? If you've got a flow line that's leaking gas and you can hear it, you can smell it, what's the danger there?
Similar to what Mr. Canfield said with the question, I mean, there's, ignition, potential combustibility, typically associated with just gas.
Okay, thanks.
Commissioner Messmer.
Thank you, Mr. Chair. Just a few questions, and just help me out here a little bit. So understanding that in KPK's response protocol, and you as the Director of Compliance, Environmental Compliance Response Protocol, if you've got a report of a leak, you're basing your decision-making around whether or not to report this, not on your own observations, but on the observations of a potentially trained lease operator?
That's correct. I don't have the ability to make it on site in the required time period for all the releases that occur.
Okay. And you continue to maintain that this is a non-reportable offense?
Yes.
And so when you initially repaired this line, you repaired an open-ended 3-inch fiberglass line that potentially was unloading the entire contents of a 3-inch line into the atmosphere, thinking that this was the repair that was necessary, and you're still thinking that that was an unreportable offense?
Yes, because it wasn't believed that just because obviously this open-ended 3-inch line that has been in place since.
Well, you didn't know that at the time, right? So, I mean, at the time, you thought this was an open-ended line that needed to be capped because at that time it was unloading its entire contents into the atmosphere, and that's the fix that you thought needed to happen.
No, that's incorrect. I continue what we believe when we cover the open-ended line is that it may be teed into some other form of way of isolating that line, like a check valve. So despite it being open-ended, there would have been some other mitigation on the other side that may have failed, right? So because there's no possibility that we had been operating this flow line for 5 years with a just completely open-ended 3-inch line.
Okay, and that's fair. That makes more sense. I was a little confused about that because that was a kind of a surprising thing to hear, that that's maybe just an open line, and it thought that that was a repair. But it makes more sense that it would potentially tie into a joint. So I appreciate that. That was really the question that I had, because that was a head scratcher for me.
Okay.
Other questions for this witness? Seeing none, Mr. Mueller, do you have any redirect at this time?
I just maybe to observe for the commission, the violation alleged here is that on July 15, we became aware of a reportable leak. You know, a whole lot of what we've been discussing, while it goes to explain the reason it took some while to repair this and that caused agitation to the landowner, none of that was the basis of any alleged violation. I just want to stay focused on what matters. They stopped the leak immediately. The available information indicated that it was minor and not reportable, and the stuff about subsequent excavation, repressurizing, and then having to shut it again because they realized they hadn't fixed it, that really is beyond the scope of the alleged violation. It's a little in the nature of closing. I appreciate the commission's intelligence. I have no further questions for this witness.
Okay. Do you want to call your next witness?
I do. If we're at that point, let's call Avi Mailer, please. Hi, Mr. Mailer. Thank you for joining us.
Hello.
Can you remind the commission who you are and what you do with KPK?
My name is Avi Mailer, and I'm the Vice President of Land for KPK.
Just for my benefit, Commissioner Robbins, can you all hear our witnesses? I think because I'm in the same location, they're a little foggy to me and I can get by, but I want to make sure the rest of you all can hear them clearly.
We can hear them, Mr. Mueller. It does sound a little tinny, but we can hear them.
I'll try to speak louder.
Thank you.
That would be helpful for me, you know, the oldest member of the group here. So to me, it sounds like you're underwater. So loud is good, Avi. Thank you for that. Mr. Mailer, I don't think we let you answer the question. Your position is with the Land Department in KPK, is that correct?
Yes, it is.
Okay. And did you have a relationship with the landowners at the Chilson number 5 flow line location?
Yes, I've dealt with them over the years on a number of different occasions since KP Kaufman took over operating these wells.
Who are they? Can you tell us?
It's predominantly a father and 2 daughters, Todd Thomas, and his daughters, Alex and Brandy Thomas.
So with regard to this event, can you describe a little bit of your communications with them? And if it's helpful, let me share my screen. Because a number of your communications were by email. Mr. Mailer, you can see this screen, can you?
Yes.
The problem with emails is they all start at the bottom, at least in most formats, they start at the bottom and work their way up. But I wonder if we can kind of talk through your communications. It looks like there was an email from the Thomas family to you. It was from Brandy Thomas starting on July 15. Can you kind of tell us how the communications went?
Yes, as mentioned earlier, we were initially notified by the landowner on July 15th, and it came through the means of this email. and they notified us of this leak and wanted to know what the next steps were.
For the record, the phrase potential leak has come up. I would note that that was a stipulated fact. It's on page 19 of stipulated facts that we lodged with the commission. KPK was notified by the landowner of a potential gas leak on July 15. I think that Mr. Knopp has clarified there was the word potential there goes to who was responsible for the leak. So
Yes.
here you have Randy Thomas saying, we were told that the gas came from a KP Kaufman line. Is that right?
Yes.
And tell me what the essence of her communication was as you see it or recall it.
It was just to notify us and to make us aware, and then for us to go out there and repair it.
She says in the last line of the paragraph, let us know your schedule. Is that correct?
Yes.
And going back up, you responded that same day, it looks like?
Yes. And I had mentioned to them, as indicated in the email, that I had already spoken to the crew and that they had gone out there, shut down the line, and isolated what needed to be isolated, and told them that we were planning the cleanup for this line.
Okay, and then there were ongoing communications, and I guess I don't want to, for the sake of time, get too down into the weeds on these, but on the 23rd, you exchanged emails again with the Thomas family.
Correct.
And then again on August 10, it looks like there was an exchange.
Correct.
And what did you understand was the primary concern based on your communications with the Thomas family?
It was just that they were wanting to know when we would have the ability to come and repair this line.
As we've heard, this line didn't turn out to be a quick fix, and so they continue to be concerned to get the job done. Is that accurate?
Yes, that is.
So there's a jump here from August 10 until the 13th of October before there's another email exchange. You see that?
Yes.
And then there's more emails on the 14th and thereafter. You see those?
Correct.
In addition to wanting the job completed, they had some preferences for how it was done. Am I recalling correctly?
Yes, after we had commenced cleanup operations and repairs, they had requested a certain seed mix that they had a preference for us to use. They indicated that they would get that to me, and once they did, I passed it along to our crews, and that was ultimately what was incorporated into the mix.
So they got the seed mix they asked for.
Exactly.
Did they ever complain to you or express concern about horses?
Never.
Or livestock?
Never.
Or the peril of being blown up?
No.
There was another email that was outside this chain that suggests communications between this before this last October communication. Let's see if I can call it up. This is October 2nd. You're writing back to Brandy Thomas. Sorry, it's taken a few days to respond to your phone call earlier this week. Did you have telephone calls with them in addition to these emails?
Yes, I did. As indicated by this email, Brandy had reached out earlier that week. As they frequently do, all three of the family members have my cell phone number, call it when they feel is necessary, text me. So this email highlights that she had called and then responded October 2nd as a courtesy to let her know that I would be passing along their request to our crews.
So the longest gap we can piece together just based on paper trail, sometime second week or so in August to early October, although there may have been telephone calls in there. Is that also, do I have this right?
Yes.
Do you still have communications with the Thomas family from time to time?
I do. They will from time to time ask me questions about our assets vis-a-vis their properties. They have a future housing development planned adjacent to this property. The current property that we're dealing with is where they have built their homes. Each one of them has built a home out there.
And they know how to reach you by cell phone and email?
Yes.
And they're not bashful about doing that?
Not at all. And I've met with them on site multiple times over the years.
Mr. Chairman, I have no further questions for this witness.
Thank you, Mr. Mueller. Cross-examination, Ms. Stafford.
Thank you, Chair Robbins. Just a few questions here. Hello again, Mr. Mailer.
Hello.
I'm sorry if I mispronounced your last name. I did get it right? Okay. Sorry. So I want to turn to your testimony just now. So you and Mr. Mueller just went through your interactions with the particular complainants in this matter. Is that right?
Yes.
Okay. And I'd like to share my screen right now. I'm putting up what staff has marked as Exhibit 500. I believe KPK marked this as Exhibit N, and this was the email chain that we were just going through. Does that look right?
Yes.
Okay, so we have on July 15th this notification from, excuse me, I scroll down a little bit further. The initial notification from Brandy Thomas to you discussing the leak. And then we have your response on July 15th. Does that look right?
Yes.
Okay. And now I believe we sort of scrolled through these particular pieces during your testimony. So I'd like to touch upon these a little bit more specifically. So the next communication we have is Thursday, July 23rd. And I'm gonna read this. And if I read this wrong, please let me know. Avi, what's the update? The below still hasn't been done yet. Does that reflect what's in the email here?
Yes.
And then you respond the same day to say that, quote, I was under the assumption they took care of this, end quote, and that you reached out to Cruz and they're attempting to get out there early next week. Is that right, generally?
Yes.
Okay. Moving on, then we have another communication. So we have a gap here from July 23rd to August 10th. And again, I'm going to read here and please let me know if I've read this wrong. Avi, this still hasn't been cleaned up yet and is very close to a source of water. When will your team be on site to fix the broken pipe and replace dirt? Did I read that right?
Yes.
And then again, we have another communication from the Thomas family shortly after Brandy Thomas sent an email that says, hi, Avi, please clean up to our satisfaction and oil and gas standards so we don't have to notify the Colorado Division of Oil and Public Safety of this incident. Please give me a call to discuss your plan of action and response time. Did I read that right?
Yes.
And then you respond on the 10th, again apologizing for the delay and confirming that the crew will be out there by Wednesday to clean up the property. And is that right?
Yes.
So that would mean, this is Monday, August 10th. That would mean that your crew should have been out there Wednesday, August 12th, 2020. Is that right?
Yes.
And when did the crew actually get to the Thomas location to begin remediation work? Or excuse me, yes, remediation efforts.
Sometime in October, I believe, maybe early November.
Well, so Mr. Miller, did you hear Mr. Canfield's testimony earlier today?
I did.
And he referenced an understanding that KPK showed up on location to begin remediation efforts on August 24th, 2020, with no notice to the landowner. Is that right?
I believe he said that, yes.
Okay, so we have the August 10th date here, and then we have the Wednesday, August 12th date that you promised to get out to the location. Mr. Mueller put up another email that said that you had some communication now sometime in late September, early October. So were those the only communications you had with the complainant before they filed the complaint in this matter?
Through email?
Through email, call, text, any communications?
I don't recall if I got a phone call from them, but through email, this is what I have.
Okay, and the calls you reference, I believe the other day you mentioned you keep a log of interactions you have with complainants. Is that right?
I don't keep an official log, but I do have.
I'm sorry, a notebook of some sort?
I have a notebook that from if I have a message to remind myself to call someone back.
Okay, I'm sorry.
It's okay.
And was this, were the contents of this notebook submitted into evidence, do you know?
No.
No? Okay. So just to be clear here, we have the communications that we've spoken about in August, the potential communications via phone in September, the email October 2nd that Mr. Mueller showed during your direct testimony. And then we have this email from October 13th, 2020 that says, Avi, I want to make you aware that because the site is not fully cleaned up, we submitted a complaint with the COGCC today. We hope that this will spur some action. Did I read that right?
Yes.
I don't have any further questions for this witness.
Thank you, Ms. Stafford. Mr. Mueller, any redirect?
Mr. Mailer, the email we just closed with says, I hope this will spur some action. You see that?
Yes.
It doesn't say, I hope this will spur some good faith communication from KPK.
That is correct.
This landowner was agitated because the job wasn't moving as quickly as they wanted. Is that correct?
Yes.
Do you think that's understandable?
Yes, I understand.
But you were doing your best in good faith to communicate with them, were you not?
I was, and like I've done with them in the past, I've always had an open dialogue with them. And as indicated prior, they are never bashful to reach out, and they know how to get a hold of me.
No further questions.
Okay, commissioners, does anyone have questions of this witness? All right, thank you for your testimony. We will allow you to be removed or leave, and we might see you again. And thanks for being with us. And we're looking for the next witness for KPK.
Thank you.
Taylor, appreciate it. Chairman, our next witness is going to be presented by my colleague, John Jacobs.
Very good. Mr. Jacobs?
Mr. Chairman, Mr. Rick Stoltz will be our next witness. He's participating remotely, and so I would ask the hearings manager to make him a panelist. If we could pause the timing.
Very good.
Richard Stoltz, S-T-U-L-T-S.
He's in.
Great.
And Mr. Jacobs, was Mr. Stoltz sworn in at the beginning of this proceeding?
Yes, he was.
Okay, thank you.
Everyone. May I proceed? May I proceed?
Yes, please.
Thank you. Good afternoon, Mr. Stoltz. Please state your name and current employment position.
My name is Richard Stoltz. I am an independent contractor.
And how long have you been consulting for KP Kaufman?
I was originally hired as Vice President of Finance and then promoted to CFO. I was an employee with Mr. Kaufman or a consultant for over 15 years.
Thank you, Mr. Stoltz. And briefly, what's your education and professional licensing?
I have a Bachelor of Arts in Accounting from Hastings College, Nebraska, and a Master of Science in Finance from Colorado State University. I also hold a non-active CPA license in the state of Colorado.
Thank you. what other experience do you have besides with KP Kaufman as a CFO and consulting as a part-time CFO?
I was a CFO and controller for a construction company that provided engineering, materials procurement and installation, focused in the telecom industry. And then I also have 14 years commercial lending experience with major regional bank systems with a focus in oil and gas and midstream gas processing lending.
We could pause the time for a moment. Mr. Stoltz, I don't know if the others are getting sort of a volume up and down for his audio. Are you? Or is it good audio for you?
I think it's pretty good. Everybody else
okay.
Good?
That's fine. I just wanted to make sure they were able to hear you okay. Great. Let's continue. Sorry for the interruption. Did you have occasion to prepare information on the KP Kaufman Company's ability to pay in connection with a United States Environmental Protection Agency, Department of Justice, and Colorado Department of Public Health and Environment Clean Air Act case in federal district court in 2019?
I did.
Can you tell us what prompted that?
The EPA and the CDPHE had brought action against KP Kaufman, alleging the design of the tank batteries were inadequate to route all emitted vapors through emission control devices. Judge Brooke Jackson ordered mediation to be conducted by Federal Magistrate Judge Kristen Mix, and I presented to Judge Mix, the EPA, Department of Justice, CDPHE, on KPK's ability to pay significant civil penalties that were being sought by the plaintiffs.
Thank you, Mr. Stoltz. In very general terms, what did this presentation and mediation cover?
It covered KP Kaufman's historical production levels, historical financials, and then based on that information, financial forecast information. It was in Judge Mix's chambers. The presentation took about an hour and a half.
Did that presentation involve reference to a financial model used to forecast and determine ability to pay?
Yes, sir. It was a model that I developed. It's designed on a monthly basis. It goes back and captures historical production for KPK's properties by region and major field, going back to the early 2000s, and then it encompasses every general ledger account in the balance sheet and the income statement since December 31st of 2012. It utilizes this historical information, known obligations for the future, current trends, current commodity prices, to then forecast production financial statements, which include a balance sheet, an income statement, a statement of cash flows for each of the subsidiaries, the parent, and on a consolidated basis with everything tied together.
Thank you. That federal court action settled as a result of the mediation, did it not?
It did.
And that settlement is memorialized in a consent decree, correct?
Correct.
And is KPK's Jolson Exhibit R that consent decree? I can pull that up if you'll bear with me. Let's see. Just a moment. Can you see that?
Yes.
And is that the consent decree that resulted after mediation in Magistrate Mix's chambers that you described?
It is.
Thank you. Without getting into specifics, did your presentation result in lower civil penalties as part of that settlement?
It resulted in significantly lower civil penalties.
How much was agreed to in penalties after mediation and your presentation to EPA as documented in the publicly available consent decree, KPK Gilson Exhibit R?
It was $1 million in penalties with payments that began within a month of the formal filing of the decree. So there were 8 installments over 3.5 years, equally split between the Department of Justice, EPA, and the CDPHE. And then on the 4th anniversary, there was a balloon payment. There is a balloon payment due.
And that consent decree was entered in January of 2020, I believe.
I want to say it was filed more in April of 2020.
Okay. That's right.
And also
earlier. Go ahead, please.
The company also agreed that over the life of the decree, this doesn't capture everything, but the company was going to spend $2.5 million consolidating tank batteries, adding additional vapor control systems, and then converting a number of plunger lift wells to rod pump wells.
Great, thanks so much. Did the Department of Justice, EPA, and CDPHE have any accounting assistance in their consideration of your presentation made in Magistrate Mix's chambers?
Yes, they jointly engaged a forensic accountant that they flew in from Washington, D.C.
As a part of the company's preparation for this hearing and for possible settlement as well, did KPK engage its own forensic accountant?
Yes, Melinda Harper and Greg Weiss with Harper, Hoffer and Associates in Denver.
And as a result of that engagement, did you provide financial information to Ms. Harper and Mr. Weiss?
Yeah, I took the model that I had, which incorporated the audited financials through December 31st of 2018. I updated it for unaudited financials through March 31st of 2021. I updated production through May of 2021, and I updated it for actual payrolls through June 30th of 2021. I also had a lengthy interview with Mr. Weiss at Harper Hoffer to explain the structure of the model, how it tied together, and then how he could adjust assumptions as he saw fit.
Great. Since the consent decree was entered as a final order of the court, I believe in April, as you indicated, have there been significant impacts to April of 2020, excuse me. Have there been significant impacts to the company's financial condition affecting its ability to pay the significant penalties sought by commission staff in this proceeding?
Yes, sir. You had COVID hit, which significantly impacted operations and significantly impacted the oil price environment. So the revenues received on production was dropped dramatically, particularly during the first 3 to 8 months after COVID hit.
So that's, if I heard you correctly, 2 developments. One is COVID and the other is commodity oil prices?
Yes, it's basically COVID affected operations. Operationally, the field is structured such that you have teams of 3 to 4 crews on roustabout and workover rigs. And when COVID hit, 37 employees in the field were affected by COVID, which meant whether they were quarantining or sick, they were out a minimum of 2 weeks. That impacted the crew size, et cetera. If it was a pumper, then there was then an inability. People had to be stretched to then cover the wells that were being pumped by that pumper. But bottom line is they were out for at least 2 weeks, which then dramatically impacted crew efficiency, which then led to a reduction in repair and maintenance on the wells, which then resulted in declining production levels due to wells being shut in.
So those wells were shut in as a result of, or certain wells were shut in, causing your production to decline?
For safety and environmental reasons, yes, they were shut in.
Yeah, thank you for that clarification. Did this affect all job functions at the company?
Impacted all job functions, but the other piece that I want to mention is average NYMEX crude oil price was $57 in 2019. It was 50 in February of 2020. March, it dropped to 30. April, it dropped to 16.70. May, it dropped to 28.53. So the first 3 months, you had an average oil price of 25.23. So now I have declining production and declining revenue due to the commodity prices dropping so significantly. And ultimately, that shows up with further reductions in particularly the office in the form of layoffs or reduced payroll or ultimately furloughs towards the end of the year.
Thank you. I believe you addressed the COVID impact. Is the COVID impact and the commodity price drop reflected in the financial model that you provided to Mr. Weiss?
Yes, sir. The impact of the prices and the impact of the reduction in production levels are in fact reflected in the historical results of the company's financials, which are included in the model that was transitioned to Mr. Weiss.
And I believe, bear with me, you provided additional information to Mr. Weiss as well, besides the model. I'm going to, again, share my screen. Do you see this attachment 1 reference labeled Gilson Exhibit Q?
I do.
And do you recognize the information in that list?
I do.
And is that the list of information that you provided to Mr. Weiss to review and rely upon in the formation of his expert opinion?
It is.
Thank you. I appreciate your testimony. I have no further questions for Mr. Stoltz at this time.
Ms. Stafford?
Thank you, Chair Robbins. I think we just have a couple, and then I think that should be it. So good afternoon, Mr. Stoltz.
Good afternoon.
Now, you just testified to the impacts that the pandemic had on KPK over this last year or so. You know, with all these impacts to employees that you list, why not just shut in wells until you're able to safely operate?
Wells were shut in. As they went down, a lot of these wells were shut down because we simply didn't have enough crews to repair them.
Understood. And then I guess, commissioners, if I could, this isn't necessarily a question for Mr. Stoltz, but I at least wanted to make the commission aware that, you know, staff generally here does not take a position on KPK's inability to pay argument. You know, it's our position right now that we just didn't feel comfortable making the call here. We think this is more appropriate for, you know, testimony for you to consider and decide upon. And, you know, we will follow, you know, the policy and procedures of the commission on this particular issue.
Thank you, Ms. Stafford. That's fine. And we understand. At this time, Do any commissioners have questions of Mr. Stoltz?
Mr. Chairman, if I may, just
Mr. Jacobs.
Correct briefly. The consent decree that KPK entered, I know we referred to EPA and CDPHE, but it was actually with the United States of America and the state of Colorado. Is that your understanding?
Yes.
That's the caption of the consent decree in federal court.
Yes, sir.
Thank you. Just a clarifying point on that. I'm done. Thank you.
Okay, then Commissioner Messmer.
Thank you, Mr. Chair. Just so I understand, this was a settlement, is that correct?
In mediation, yes.
Okay, so a settlement though.
If I may clarify, as a procedural matter, I'm just.
Okay, I'm just trying to understand it. I did read it, but it wasn't clear to me whether it was a settlement or not, so.
Well, if I may, and Mr. Chairman.
Go ahead, Mr. Jacobs.
Thank you. When certain matters are referred to the Department of Justice and a complaint is filed in federal court, it's frequently the case that a consent decree has been negotiated ahead of time, and actually the day that the complaint is filed, a consent decree is proposed and also filed. And then the court reviews the consent decree to see if it is consistent with the requirements of the statute and is fair and reasonable. And if it is, it's entered as an order of the court and enforceable as an order of the court. So the court has continuing jurisdiction. So while this is a settlement, it is also litigation because a complaint was filed and resolved as soon as the court is satisfied that it meets statutory requirements and is fair and reasonable. That is the difference between the execution dates of January, when it was lodged with the court attached to a complaint, which was filed as a pleading, and April, as Mr. Stoltz testified, when it had been subject to notice and comment in the Federal Register, and then the judge was satisfied that it was fair and reasonable and consistent with statutory requirements. Sorry for the long-winded answer, but I hope that clarifies your question about settlement.
Could I actually make a clarification here?
Absolutely. I have no objection.
I'm looking at the consent decree right now, and just to clarify for the record, the complaint against KPK filed by the DOJ, EPA, and CDPHE was filed on October 5th, 2018. So the complaint was not attached, or the consent decree was not attached to the complaint here. And I just want to make sure that is abundantly clear.
Mr. Jacobs?
I stand corrected. The procedure I described is common. I was not involved in this federal litigation, but consent decrees are required over a certain dollar amount. EPA doesn't have authority to administratively settle a Clean Air Act case above several $100,000. They're referred to the Department of Justice. And that procedure I described, I apologize, I wasn't involved in the underlying litigation. That did go to court, then it went to mediation, and then a consent decree was entered. So I stand corrected, and Ms. Stafford is absolutely correct.
All right, thank you, Mr. Jacobs. Thank you, Ms. Stafford. Commissioner Messner, coming back to you, do you have further questions?
No, that actually answers it. Thank you.
Okay. Other questions from commissioners at this time? All right, seeing none, I think we can allow Mr. Stoltz to be released.
Thank you, Mr. Stoltz, for your testimony.
Thank you.
Our next witness will be handled by Mr. Mueller, so I'll turn it over to him.
Mr. Mueller, you're muted.
Thank you, Chairman. I'm just watching to see if Greg Weiss, our next and last witness, is in the witness room, and there he is. So, Mr. Weiss, can you hear me?
Yes, I can.
Good, and I can hear you just fine. That's terrific. With your permission, Chairman, we'll proceed.
Go ahead.
Mr. Weiss, good morning. Would you state your name, please, for the record?
That's Greg Weiss, W-E-I-S-S.
And Mr. Weiss, who are you employed by?
Harper Hofer and Associates.
And you were hired to assist KPK in regard to this matter. Can you tell us what your assignment was?
Yes, I was hired to evaluate KP Kaufman's ability to pay the proposed, I think it's $3.7 million penalty assessed by the commission.
And can you tell us a little bit about your qualifications to undertake such work?
Sure. I have an undergrad in business administration with an emphasis in accounting from the University of Northern Colorado. I have a master's in business administration from Rockhurst College in Kansas City with a dual emphasis in finance and international business. I'm a Colorado licensed certified public accountant. I also have additional training and certified by the American Institute of Certified Public Accountants in financial forensics. And I also do ability to pay analysis in a couple of different areas of my practice. One is with environmental litigation, primarily with the Department of Justice on behalf of the EPA and CERCLA cases, then also in a bankruptcy practice as part of a solvency analysis.
So both in the context of CERCLA and in the bankruptcy context, evaluating a entity's ability to pay is sort of crucial work, and you've performed that before?
Yes, I have.
And have you been certified to testify as an expert witness previously in regard to litigation?
Yes, I have.
And did you prepare a report summarizing the work that you had performed in connection with this matter?
Yes, I did.
I'm going to just pull it up and flash it on the screen for you and the commissioners to see. This is our exhibit JJJ. It is a redacted version of your report, Mr. Weiss. Long story short, we don't want to put specific confidential business information out in the public right now. I know you're aware of that.
Yes.
So here, for your benefit and the commissioners, is a redacted version of your report. With all that by way of introduction, can you tell us what you did to prepare this report?
Yes. So the first thing I did was meet with Mr. Stoltz in his office. During that time, he walked me through what he'd given to us, including the audited and unaudited financial statements and his model that he uses to do projections. And as part of that process, he walked me through kind of the mechanics of the model, how the model worked, how everything flowed from one schedule to another, and then where the key assumptions were located and how those flowed through the model.
And having evaluated his model and the assumptions upon which it was premised, did you develop an opinion about his model?
Yes. So in addition to just meeting with him, after we got a copy of the model and the underlying data, we did a thorough analysis of the model, going through making sure that the formulas in the model were consistent, that the logic of the model made sense. And we also did some stress testing of it where we went in and changed some of the assumptions to make sure that the model responded the way we thought it should.
And I'm sorry, I interrupted.
No, go ahead, I'm sorry.
And what did you decide, having stress tested and otherwise evaluated the model?
After going through the model, we did find, I think, 3 or 4 instances where there were some formula inconsistencies. All those inconsistencies had to do with past years and didn't impact the calculation of future cash flows. So in our model, we went ahead and corrected the errors we found, retested it, found that everything was working properly, and then moved forward after that.
So as a liberal arts major, what I hear you saying is you tweaked his model a little bit and then put it to work.
I wouldn't say tweak. No, we just corrected a handful of formula errors. Okay. And like I said, those really had no impact on the future cash flows that we were using. It impacted prior years, but we just wanted to make sure that the model we were using was absolutely correct.
So in addition to evaluating and employing the model, did you do anything else to evaluate KPK's ability to pay?
Yeah, so after we did that, we evaluated the expected future cash flows of KPK using Mr. Stoltz's model. Although we didn't just take the numbers that the model spit out, his model is really set up to do financial reporting.
And so cash flows and financial reporting are really different than how you'd look at cash flows for ability to pay. For ability to pay, we use something called free cash flows, which are essentially all the cash flows of the company after paying ordinary expenses that are then available to pay either returns on equity, repay debt, or to pay penalties and things like that that are outside kind of the normal operations of the company.
So with regard to free cash flow and the other factors, did you develop an opinion about KPK's ability to pay the fine that's been assessed at the outset of this proceeding? And I will tell you that the numbers have fluctuated for reasons that we're all aware of, but we don't need to go into right now. At the outset, it was a 3.7 recommended penalty, 3.7 million. Did you develop an opinion about whether KPK has the ability to pay such a penalty?
Yeah, I looked at it both as paying as a lump sum and then paying over time. And my opinion is that they cannot afford to pay the $3.7 million either as a lump sum or even over 5 years.
Would your answer differ if the number were 3.4 million?
No, it would not.
How much would they be able to pay either in a lump sum or over time, Mr. Weiss?
Based on my analysis, it came up with $795,000 over 5 years.
Weiss, is there anything else, without getting into the matters that I've suggested are confidential and redacted from your report? Is there anything else you would share or draw our attention to with regard to your report?
I think the only thing that's probably important for the commissioners to understand is that the assumptions that are used in the model really have a big impact on the cash flows. So for example, we used the spot price for oil and gas at July 1st, which was $75 for oil and $3.75 for natural gas. Both of those numbers have come down significantly. I looked right before I came in. I think natural gas is down to about $3.69, I want to say, versus $3.75, and or natural gas is down like to almost $1 from what the model had. So, but it all fluctuates. I looked at a bunch of different companies' expectations for future commodity prices, and they're all over the map right now because everything's so uncertain. So we just left it at kind of what they were at the beginning of July, which seems to be kind of the midpoint of what everybody thinks anyway. So,
thank you, Mr. Weiss. That was very clear and succinct for somebody who doesn't follow this stuff very carefully. I appreciate your testimony and have no further questions at this time.
Okay.
Ms. Stafford, did you have cross, or are you just allowing the commissioners to absorb this information and work through it?
I don't believe staff has cross, no.
Okay. Commissioners, questions for Mr. Weiss? Commissioner Gonzalez?
Thanks, Mr. Chair. Thank you, Mr. Weiss. What would happen if there was a $3.7 million penalty lump sum assessed for KPK?
I don't think they could pay it without, I'm not sure what they would be able to do to fund that kind of money. They'd have to find some way to borrow it or be able to sell off enough wells to cover it. Given the current economic conditions right now with how oil and gas market is, I think it'd be very difficult to get that money.
You mentioned $795,000 over 5 years. What's the lump sum associated with that amount? Did you run that model or run the traps on that?
Well, that $795 is the lump sum. It can either be paid all at once or be paid over 5 years. I didn't discount it back at any particular rate.
So paying in installments does not increase the ability to pay above that amount?
I mean, if you extended the time frame out, I suppose it would extend how much they could pay. It just depends on the time. I used 5 years because that's typically what we see. Especially like in circle litigation where they have these consent decrees, a lot of times they're over 5 years.
Thank you, Mr. Weiss.
Other commissioners with questions? Okay, I'm not seeing further questions. Mr. Mueller, I believe we are done with this witness.
We are done with this witness, and we are done with our presentation as to this NOAV.
Very good. All right, then I believe that this NOAV, I'm trying to find the number, 402571143 is fully submitted to the commission at this time. And I believe at this time, we would look to staff as well as Mr. Mueller and Mr. Jacobs. Do you have any additional process questions this afternoon?
Chair Robbins, yes, staff does have just a quick point of a quick point of order, and I would turn it over to Ms. Rosenberg as she will elaborate. You're on mute, Kelly.
Sorry. Thank you for your time. And I just want to, I think, confirm that our understanding is consistent with everyone else's. At the outset of the hearing, the parties agreed that documents for which there were exhibits for which the only objection was foundation would be deemed authenticated and admitted into the record. And then I just want to point out that it is my understanding, based on the tracking I was doing during the case, that neither party then admitted into evidence or attempted to admit into evidence any of the other documents that had objections in addition to foundation. And so to the extent those documents were used as demonstrative exhibits, they were never admitted into the record.
Mr. Mueller, Mr. Jacobs, do you want to respond or provide your perspective on that point?
Yes, thank you, Mr. Chairman. I think that that's correct. We've noted certain demonstratives that were based on exhibits to which we have objected beyond simple foundation objections, which we've waived, and those foundation only exhibits on both sides are agreed admissible and deemed admitted. But we have not resolved the admissibility and entry into evidence in the record of these proceedings, those exhibits that are still subject to beyond foundation objections, hearsay, et cetera.
Okay. Okay, then I think we've re-perfected the record in terms of what exhibits have been admitted and what exhibits have not been admitted. So thank you for that, Ms. Rosenberg. Did you have more, or was that your point?
That was the point. Thank you.
Okay. At this time, I believe we are done with the hearing for today. I believe we're coming back tomorrow morning for oral argument on the statute of limitations, as well as closing statements on behalf of both sides on these first 5 NOAVs. Commission has noted a potential executive session if we think we need that. And then at that time, we would close the agenda for tomorrow and we would take up deliberations on Monday. I would remind attorneys for both sides that until we close the record, the commissioners have the ability to desire to ask a question of any witness that has been called to date. And so please do have your witnesses available if at all possible in the morning. I anticipate closing may generate questions. And so if that's available, that would be helpful for us. AG Davenport, do you have anything further at this time?
Thank you, Mr. Chair. No, I don't have anything further at this time.
Do either party have anything further at this time?
I do have one clarification on your last comment, Mr. Chairman. I believe counsel for both parties has known, and we've made clear that our witness, Mr. Mike Haddle, would not be available tomorrow, certainly, and I didn't think either today. He's got a family obligation, his son's wedding on the 14th. So I believe he is not available, and should there be any questions of commissioners for Mr. Hattel, that will be a complication. Perhaps there won't be questions for him.
Okay. Thank you for letting us know that. I believe, again, the rules of evidence are not quite as tight in this courtroom as in the district courtrooms across the way. And if we do have questions that get into the area in which Mr. Hattel is around, we might be able to locate a different witness from KPK that was aware of the work that Mr. Hattel did, and maybe we can approach it that way if we end up with questions along those lines. But thank you for letting us know that, and
useful.
commissioners, be apprised of that as you go over your notes this evening in anticipation of getting prepped for closing tomorrow. Anything further from you, Ms. Stafford?
Nothing further from me. Thank you.
Okay. Anything further from my fellow commissioners? Commissioner Nanjapa?
Thank you, Mr. Chair. Is it an appropriate time? There's a couple of outstanding questions I have kind of in preparation for closing and deliberations and et cetera that could I request some additional information from the parties?
Go for it.
So in particular, I was curious if we could get, I don't know if this would be from COGCC or best straight from KPK, but the average production from the past 3 years from these locations in question in the NOAVs. And also in light of some of the testimony that we just heard, the expenses for operating these facilities and wells in question. And then I think we saw, I know there was some record of the truckload manifests for the soil spread field, but I would also be interested in seeing the truckload manifests from the NESU site to the landfill, if that's possible. If that is already in the record, please just point me to the correct
I want to say yes, but I don't mean to get ahead of myself. So, so noted, Commissioner.
Okay, and I will do a search myself this evening as well. Thank you.
Made a note of that, and with Mr. Mueller's assistance, hopefully we can be responsive and timely. But I do have a clarifying question, Commissioner Nanjapa. I believe you indicated average production from the NOAV locations. Some of those are off-location flow lines. And so I'm accepting those. There's really no production. There's throughput, perhaps, from a number of wells, depending on what wells are served by a flow line. Are you accepting flow line locations from that request?
Yeah, I think that's fine.
Okay.
But then it would be more pertinent for the sort of just operating expenses, you know.
Sure. And that's lease operating
testing.
expenses? Oh, excuse me, I didn't mean to talk over you.
Yeah, no problem. Just things like, you know, overall sort of expenses of operating, including testing and maintenance and, you know, those types of expenses that you incur year on year.
Oh,
If that's possible.
absolutely. And certainly lease operating expenses, or LOE, are commonly tracked because they have to be accounted for to any other companies participating in a well, royalty owners and the like. And that is the type of expense that I believe we can easily provide. Would that be satisfactory?
Yes, thank you very much.
Very good.
And Commissioner Nanjapa, I apologize. What was that request about the manifest? Was it from NESU to the soil spread field?
No, if I understand correctly, and would allow the parties to correct me if I'm wrong, I believe there were some truckloads that went from NESU straight to the landfill, and then there was those that went to the soil spread field, and I believe we have the records from those that went to the spread field. But I am just curious about those that went to the landfill as well.
Yes, okay, and I do believe that that's in the record. I'll locate it though.
Thank you very much.
Commissioner Nanjapa, I actually know where those are, or at least some of the manifests that I think you're speaking of. If I could direct you to exhibits 119 and 120 from the NESU #1, those are staff exhibits. And then they are also, I believe they look very similar. They are also attached in the spread field matter as exhibits 819 and 820. But we will also check our records to see if there are additional manifests that we perhaps overlooked or something.
Thank you very much. As you know, there's a lot of material to go through, so I probably just did not see that as I was skimming through, so thank you.
One last concern related to the lease operating expense request for the benefit of the parties and the commission. That may also be confidential business information, I'm informed, and we would treat it similarly to the financial information provided to Mr. Weiss by Mr. Stoltz on behalf of the company. That's acceptable.
Yeah, for me, that is fine. Thank you.
Very good. Thanks.
Commissioner Messner.
Thank you, Mr. Chair. Along those same lines, for me, while I appreciate the trucking manifest, it appeared to me from testimony that there was an account with the Front Range landfill that would have documentation of loads that were dropped off there and volumes of loads and amount paid. I find that would be helpful on any associated NOAVs from the Front Range landfill itself, and invoices associated with that. And then, and this could be part of the record. I thought I've gone through and read all the exhibits, but perhaps I've missed it. But there was some documentation. There was some testimony around documentation of pressure tests on any of the associated flow lines with these NOAVs. And I think that would be helpful to see, as well as any, it doesn't sound like there's very many maintenance logs, but if there are any maintenance logs or functionality tests, I think that would be helpful for me to see as well. Yeah. Thank you.
Just, Commissioner, to make sure I understand with regard to the Front Range landfill invoices, those were the subject of the NASU 1 and the soil spread field NOAVs. Were there any others?
I think that was it, although perhaps I was just going through my notes here quick. I mean, that's why I just said associated NOAVs, because I thought perhaps the Pan Am one had some too, but I haven't fully gone through my notes to fully know that yet. And so if there were other associated ones with these particular NOAVs, I think that could be helpful. But I did make notes on the specific ones. I haven't had time to go through them yet in order to be able to clarify that.
That's fine. That's helpful. I think some of that's in the record, but I would, if staff doesn't have it, we'll work with them to see if we can get it.
Okay, thank you.
If I could chime in, I know that there are a number of pressure tests that were provided along with forms 27 or FIR forms as attachments, I believe, and they may be in exhibits. Are there specific pressure tests that you're interested in, Commissioner Messner? They conduct a number of pressure tests from time to time.
Right. I think that and I'm trying to remember it again, and I'm just trying to give you guys a little bit of a heads up, because tonight I will review all my notes and have specific things that I'll ask for or be interested in, and I didn't want to like just drop that on you tomorrow. You know,
I appreciate
but
that.
I haven't gone through all of them yet. I just have notes that there was some testimony around pressure tests and documentation around pressure tests as answers to some of my questions, and so I'm happy to go through my notes tonight and be specific about those pressure tests, and actually review the exhibits to make sure that they, aren't in there, because they could very well be. And I will do all that this evening. But that was just the notes I had as kind of a heads up of things that I may ask about tomorrow.
Thank you, and we'll do our best to review that information as well, so we're prepared to answer your questions to the best of our ability.
Yeah.
Commissioner Nanjapa.
Sorry, thank you, Mr. Chair. That just triggered one more thing. I just was asking in one of the recent matters here about what the typical pressures are carried in the 3-inch fiberglass line versus the 10-inch steel pipe. I was just, that just is a couple of things I'm just thinking through that would help me.
I believe, if I may, Mr. Chairman, that there was prior testimony that those 3-inch lines had a normal operating pressure for certain of these locations of 20 to 40 pounds. But we'll reconfirm that, and certainly happy to highlight that prior testimony for Commissioner Nanjapa.
Thank you, Mr. Jacobs. I guess I had in my notes, or maybe I have it misrecorded, that was what was in, that was for the 10-inch line. But if I have that reversed, then yeah, it would be great if you could just clarify that.
We'll do our best. Thank you.
Other comments, questions, thoughts, concerns? All right, I'm not seeing any. I think we're looking for a motion to adjourn to 9:30 tomorrow morning, August 13th.
So moved.
Second.
Motion by Commissioner Nanjapa, second by Commissioner McGowan. All those in favor signify by saying aye. Aye. Any opposed? We'll see you in the morning.
Thank you.